where content has no shape. And Lucy's tight box comes in first. Lucy does dabble, Lucy does Dabbleverse, she does dabble, Lucy does Dabbleverse, Lucy does Dabbleverse. Lucy tight box brings the facts, and she breaks them down for us. Lucy does Dabbleverse. La la la, Lucy has a tight box and she shares it with dabblers. No, not like that, but she does this show for us. Lucy does dabble, Lucy does Dabbleverse, 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 yes she does, yes she do it, yeah right, Lucy does Dabbleverse, yes she does, Lucy does Dabbleverse. Lucy does Dabbleverse, she does. Lucy does Dabbleverse, she does. Lucy does Dabbleverse.
Oh.
Hello, everyone, and welcome to Lucy Does Dabbleverse with Luigi Greenberg, the absolutely amazing Luigi Greenberg, and of course, our very special guest, Dr. Steve from Weird Medicine.
Thank
I
you.
am so excited to be here today.
I am too.
I'm very confused.
It's an honor to be here with Dr. Steve. Welcome, Dr. Steve.
Hey, thank you. Thank you. Thanks for having me.
We are so excited. Dr. Steve, you need to keep Luigi and I on track because, of course, today we are going to be going over everyone's favorite LOLsuit. And I just wanted to start off today's video in light of recent filings and the fact that it's almost Rosh Hashanah, wishing everybody a very happy new year. L'Shana Tova, everybody. In Judaism, we eat apples and they're dipped in honey on Rosh Hashanah. And this is because we want to have a sweet new year. And based on how the lawsuit is going, I am pretty confident that this is going to be a very, very, very sweet new year for defendants Karl and Shuli.
Yes, it'll be quite the mitzvah.
It is. It truly is.
That's what we do.
This has been a weird week, and we have so much to get into. But before we get into what has happened now, I am going to very quickly catch us up on what has already happened. And very quickly it's a challenge because, gosh darn it is so much. There have been 73 filings in just over a month on this lawsuit.
I count 74.
I believe you.
Including the letter and / correspondence to judge that was sent in on the 21st.
Oh, yeah.
Oh, that's right. Yep.
That's the sweetest new thing. We are very excited to get into that. All right. So what happened first? Well, this all started back on August 7th when Stuttering John Melendez, through his attorney Taber Benedict, or Beneduct, however you want to call him, filed a complaint and then an amended complaint alleging that Karl and Shuli used his likeness and his voice in order to profit on his public image, which they claim violates New York laws sections 5051, which is the right to publicity. Now, this lawsuit has gone all over the place since then. We're talking about couch cushions. We're talking about illegally recorded whatever the hex. It has diverted pretty substantially from the right to publicity. Would you agree, Luigi?
It is out of control. I mean, that's the only way I can really say it. This is an absolute dumpster fire circus. It's nonsense. It's pure nonsense at this point.
And that is coming from an attorney. So, of course, Luigi is an attorney. I am a legal assistant paralegal at a law firm, and Dr. Steve is an incredible doctor.
Person.
Yeah, well, come on. You're not a
layperson. In this
layperson.
situation, I'm a layperson.
Yeah. So, Dr. Steve, what would you say are some of the big points of this lawsuit up until this point that you have really fixated on?
Well, okay. the thing I don't understand is, are you supposed to be arguing your case in these documents? Because my understanding is that anti-SLAPP law was designed in New York to prevent or to protect defendants from oppressive discovery until the core motion is decided. My understanding is there's no motion has been decided yet. So
that is such a good question.
This is what I'm saying. I'm here because I'm confused and I want clarity on some of these things.
I'm confused, Luigi. Okay, I think I can speak for you also. You're confused.
Yep.
It's confusing.
I'll very confused. Later then.
It's confusing. But I think that's a really great question. So we do know one of the things that happened after John, through his attorney Tabber, filed this complaint. Karl and Shuli, through their attorney Danny, filed 2 motions, one of which was this motion to dismiss based on anti-SLAPP allegations. And what that basically said was that John is abusing the legal system, and therefore that the case should be swiftly dismissed and all of the fees should be paid to the defendants. So Karl and Shuli should get reimbursed for all the baloney and malarkey that they are having to go through.
Under a specific statute that allows it.
Yes. And Steve, you are completely correct. What that anti-SLAPP defense does is that it puts an automatic stay onto the case. And so no motions should be considered or decided until that issue is reviewed by the court. And exactly, that issue has not been reviewed by the court. So how in the heck are there 74 things for the court to look at?
Well, I'm glad to hear that Tabber loves his wife or whatever, and that they're
the love letter.
I wouldn't have known that.
She's the love of his life, Dr. Steve.
Good for him. He's got somebody. I think
so happy.
I'm not an attorney, and I've testified, and I do workman's comp, independent medical evaluations, and so I've been a witness before, but I have never in my life seen something like that in a legal document that was filed with the court.
Dr. Steve, I'm a lawyer. I have never seen anything like that before. This is really unorthodox. This is really unusual.
But will it affect the case, though? It seems to me that the judge may go, what are you doing? But it's not really going to affect the case any.
Here's the
will
thing.
It?
There is not a clear answer to that, but I can tell you it is a possibility that it could affect the case. And I'm actually going to say it's a very good possibility, because in New York, there are very specific laws, like you mentioned earlier, the SLAPP statute. That's actually what I'm referring to. Because there were so many frivolous lawsuits, they actually made laws, put them in effect, that are putting plaintiffs on notice that they could be subject to much more liability and many more consequences than the defendants if it's found that they are violating these laws. So, I think that given the jurisdiction, that there are judges with chips on their shoulders who are not going to put up with this.
Yeah.
And are going to take a look at all this and let's just say the lack of professionalism, the lack of following procedure, the lack of not knowing procedure, and just say, get out. Whether or not their judge is that type of judge, I don't know. But I'm going to tell you that judge does exist in this jurisdiction. Yeah.
So the judge,
absolutely.
Go ahead. I'm sorry. Go ahead, Lucy.
It exists in this jurisdiction specifically because this lawsuit was filed in New York County in Manhattan, where they are so inundated with cases. They have way too much on their docket already. And so SLAPP effectively is saying, don't put crap in front of us when it is frivolous. That's basically what the courts are saying to plaintiffs. And this seems to be flaunting that just left and right. It's out the window.
Wow.
Yep.
Okay. So say you're Mel Gibson and your girlfriend records your phone calls.
Yeah.
Or your wife or whatever she was. Or Pat, what was the guy from
O'Brien?
Pat O'Brien yeah, we're gonna do coke and we're gonna, that's it, and these things
Let's
come
have
out.
a threesome and
Yeah.
yeah.
What were there any consequences to those? Because those were really egregious.
Great question. You know what the answer is? No.
That's-
Never was. Never was.
Mel
Yeah.
Gibson had a reputation. Pat
Yep.
O'Brien, had a reputation. He was, he was still just recently had stopped working, I think, or he may have still been working when those came out.
Yeah. The issue, I believe, and because of the fact that there was no case to come out of those, we can only speculate as to the reasons why. There's nothing on record.
Yeah.
But I'm going to guess that the reason there wasn't anything to come out of those was because of exactly what you're saying. They were, famous people. They were celebrities. But also, Danny quotes or cites to a Supreme Court case that says that even if you have someone else, if you're a third party and you have someone else's phone calls, there's no law preventing you from playing them or profiting off of them.
So that's
nothing.
Not illegal.
It's not illegal. There's no law
Howard Stern
whatsoever.
Playing the Pat O'Brien stuff, there was no consequence to him.
No, or the person that recorded the call. There was no consequence, period.
To anybody.
Yeah, because it's not illegal. There is nothing. And that is something that I feel like really is a good jumping off point to where we are now in the case, because John or John's lawyer, whoever's writing this, I think the jury's still out because it's just so incredibly disorganized, is really citing to laws that don't exist. He's just saying he doesn't like this, but he doesn't actually give the statutory reasoning for it or the elements of the broken laws. He just says, I don't like this and I don't think they should have done this. Well, this isn't a court of morality. This is a court of law. You can't just say what you don't like.
I'm sad is not a defense.
Exactly.
I'm sad is not a defense.
So, yeah.
I do think, though, Dr. Steve, you're bringing up some other really good points here, which is that a lot of the time when these egregious lawsuits are filed, the courts still will not award the people who are being negatively impacted any of those damages. So Karl and Shuli right now, they are having to pay lots and lots of legal fees. Mm-hmm. And even though we would all like to think that they are going to eventually get reimbursed by John or, I don't know, whatever John's money is that we can all agree that he probably doesn't have, we would like to think that that's going to happen. It's very unlikely to happen, at least in my opinion. And Luigi might disagree with that. I think it would be very hard, even though they have a great case for it. The courts just don't like doing that. The courts are very, very cautious about when they're doing that because it's a scary thing to do. And judges don't like to do scary things because they like to get reelected.
Yeah. Could John at that point, if it came to that, let's just say this anti-SLAPP thing goes through and they are potentially able to recover costs, could John say, look, I'm living in my mom's house. I couldn't pay my insurance. I don't have a lot of money coming in. In other words, could he plead that he wouldn't be able to pay back their fees and the judge would just say, okay, yeah,
I think that the way that he would do that would be filing bankruptcy.
Okay.
And the bankruptcy laws in New York are very weird. So there are certain things that are exempt from bankruptcy. I don't know if this would be considered, I don't know exactly how that sort of a lien would work. It's possible that if he filed for bankruptcy, he would never have to pay back a penny, even if he was ordered to do so by a court.
But he lives in Florida, though, right? He is not established residency in New York, correct?
That's a great point. So I don't know if he would have to file for bankruptcy in Florida or not. Okay. I'm not familiar enough with that. Luigi, do you know anything about the bankruptcy laws? I know next to nothing.
I'm the same way. I don't, but I do think it might. Yeah, I don't want to speculate.
Yeah, okay.
Yeah.
I'm just curious.
Yeah, it's a great question. What if he can't pay them back? There are tons and tons of lawsuits where people get a judgment against somebody else where they never end up recouping that amount of money. That's why people go on shows like Judge Judy, because they agree. Judge Judy says, well, if you are the winner here, then I will pay the fees. And then the defendant says, oh, well, then I don't care so much because it's not going to come out of my pocket. That's how
and they
those
get
court
paid
shows
too.
work. Yes,
Yeah.
exactly. So that's
We've
the
known
advantage of
people
going
who've been
to
on
those.
those shows. Yes.
Yeah.
Yeah, they're great. They're my favorite. I can't get enough. All right, let's talk a little bit more about what has happened in the past before we
Okay.
get into what is happening currently. So, as I mentioned, Karl and Shuli filed this motion to dismiss, including the anti-SLAPP stuff. And in addition to that, their attorney also filed a motion to transfer the venue from New York County, which is Manhattan, to Monroe County, which is Rochester, about 300-ish miles away, or a 5-hour drive. And the basis for that was that events actually took place in Monroe County. And in addition to that, tons of the witnesses live in Monroe County, including myself, which is great. I'm right here. I would love it if it was venued here. Yeah. And also, of course, the New York courts are so bogged down right now. There's no reason for us to be in Manhattan. Instead, we should be in Rochester.
Did
where
I
the
see a
courts are less
graphic that he
inundated.
included too, with the Manhattan cases here and the Monroe County cases
You
here?
sure did. And boy, it's like
who
this
doesn't love a
big
good
versus
graph?
this big. Yeah.
Right.
I think you actually included that on one of your videos as well
Yeah.
that you've been making about this. Everybody go check out Dr. Steve's videos, Weird Medicine.
They're just
Amazing.
very brief AI generated summaries of what's going on for people who just want to get caught up really quickly, instead of sitting through this for 2 hours. I mean, not that who wouldn't want to do that, but they could get up to speed in like 5 minutes. That's all it is.
Yeah. They're very helpful. Okay, so then what happens after that? Tabor ends up filing a cross motion to amend the complaint a second time. And this cross motion is so baffling to me because he filed it under a new motion sequence, which does not make any sense whatsoever, because a cross motion is supposed to be across from an existing motion, so you wouldn't start a new motion sequence for it. But whatever, we all know that he's
What's
a little
motion sequence? What
goofy.
Can you translate that?
Yeah.
Good question.
Luigi, do you want to
what
field that?
What she's referring to is basically that within every case there is usually a motion filing, which is an initiation of a request or some sort of proceeding in the court, and each of the labels of these documents that get submitted to the court are a motion, a cross motion, or a response. But that is within, basically a
It's got a one-to-one correspondence.
Right. If you want to think of it as basically a subset of the actual case. He was trying to amend.
You can't add more shit to it.
Well,
so there's 5 points on the motion, and then the cross motion has to address only those things inside there.
Correct.
Got it.
What he filed was an attempt to actually amend the entirety of the lawsuit.
No.
And what he filed it as was a cross motion. There was no motion originally that he was that this was response to. So it was a real lack of professionalism.
Okay.
Yes, it was basically a lack of knowledge of how to address his amended complaint or his motions, and it basically just would cause a reader a lot of confusion to try to make sense of it. It was out of sequence. So I know
reader being the
what we
judge.
should do.
The judge. Yes.
What we should be trying to do is we should try to create straight little lines with things. Everything should be in kind of a straight little line. And so what I've put up here is a graphic that explains the correct, or at least one of the correct ways for motions that could have been filed within this case. However, of course, unsurprisingly, Tabor did not file any of those things correctly. So you'll see here, this is what ended up happening. All of his motion sequences were off of the motion to dismiss, when what should be happening is he should be responding to different things off of those things. So we should have these nice little easy to follow lines. But Tabor was not so successful at that, unfortunately,
Now,
for him.
tell me how this works. Will a judge get this stack of 74 documents and try to plow through it themselves, or will their clerks go through it, or is this person just going to sit there and say, okay, from 8 to 9 I'm reviewing this case because I need to make some proclamation about it?
I am not super clear on how the courts do that, but I believe that the court clerk will go through the documents first, kind of try to make sense of them. I believe that the court clerk is going to get incredibly frustrated when they read through this case.
Are they going to mark it up and say, Judge, this is...
I think that they are
not...
going to put a sticky note on the front of this case and say, I have no idea. Because I spent 6 hours trying to connect the dots. And by the time that I was done with that, I ended up with, it was like one of those like maps where people are trying to find the murderer. I just had like strings going this way, strings going this way. I couldn't figure a single thing out. And I have some experience with this. So you would think that I would be able to do that. Right. No court clerk is going to sit and do that. And when the judge looks at this, I think that they are going to also think that it is so egregious. Luigi, do you know any more about the behind the scenes of how the judge actually looks at paperwork like this?
Judges usually have full autonomy to implement their own processes and procedures on how this stuff gets reviewed. There's not any set way of how it's done, but I think we can all probably assume that it's going to be something along those lines of having a system in place where the clerks do the first run, organization, and preparation for the judge to review it. And yeah, that's essentially it. But sadly to say, the way that a lot of these judges operate is that they don't have to read every single page of everything. And a lot of times they just give up and they'll just say, look, I've seen enough. Yeah. Here's my decision. And in a situation like this, it could either be we keep going or we stop now. Yeah. And it's just a total flip of the coin. And honestly, it's based on the personality.
Can you appeal on the basis that the judge didn't bother to read the rest of the thing? You can.
You can, yeah.
I always say, though, this is half a joke and half real. I think it's all based on if the judge got his morning blowy. I think that it is half of what makes a judge have a good or bad day is if he woke up on the right side of the bed. And that's not entirely incorrect. That happens to all of us, right? Some days we have great days at work and some days we don't. And it's the same thing for judges. I don't think there's anything wrong with that necessarily. I just hope that in this particular case, he has gotten his morning blowy.
Which one of us is going to volunteer to make sure the judge is having a good day?
Right? Somebody get on it. God.
I think that's Luigi's job.
So, who doesn't want an avatar giving them their morning blowy? Right. That's perfect. Everybody's going to really enjoy that.
It's the fantasy of a lot of people in Japan.
Touche. Probably a lot of people in Manhattan also. So Tabber, he filed this cross motion that made absolutely no sense. And what he wanted to do within that cross motion was he wanted to amend the complaint in order to include Kate Meany as a defendant, and also so that they could add in some bits about Florida law to counteract the defendants, Karl and Shuli, saying that John doesn't even have the right to file this lawsuit because he wasn't a resident of New York. Now, this is also baffling because the whole point of lawsuits is that you don't get a second bite at the apple. And effectively, what John and Tabber have done with this cross motion is that they have used the defendants, Karl and Shuli's, two motions in order to entirely change their arguments. And I think that the reason that they had to do this is because they knew that they fucked up so irreparably within their first complaint, within their first amended complaint. And they also knew that they could not discontinue this action and start a new one because the statute of limitations had run. And so their only hope was to file this motion in order to amend the complaint a second time, which is absurd. And one of the most absurd things about that is that they keep treating this motion to amend to add Kate Meany as if it is already part of the case, even though a judge has not yet granted that relief, even though a judge has not yet said, yes, Kate Meany is part of the case. And you cannot do that. That is not legally, procedurally correct.
And Dr. Steve, if you remember, those are the documents that they filed 3 different times.
Right.
Because they realized the mistake of addressing it as if the judge had already approved it. And they filed an amended
amendment to the amendment.
And then they filed an amendment to the amendment, and then an amendment to the amendment to the amendment, because they kept fucking up.
the Department of Redundancy Department.
Yes,
Amazing.
Exactly.
So
amazing.
One of the things is that the contention against the cross motions is that they are, quote, automatically stayed by law. Can you explain that? Is that what you were telling me before? Is that the judge can't, or the court can't act on anything because they haven't even looked at the SLAPP law yet?
That's
Is that
exactly
what that's
it.
about?
You
Okay.
got it.
They're trying to
You
try
got
the
it.
case in these documents. And when you file a document, you can't just go in and delete it and go, whoops, I'm going to put something different in. It just adds to the list every time you correct something.
It adds to the list,
Oh.
and a thorough judge is going to try to understand why each of those was done, because they can't be erased. And I made this analogy to someone, and they used it on the show recently, which was, it's basically like shitting on top of the already clogged toilet at this point for them, in which they made the mess and they are making it worse by doing this.
Right.
So, yeah.
They really are. They really are.
Wow.
All right. So what else? More catch-up stuff before we get into the new stuff. Next, we get co-counsel entering into the case. We get co-counsel and part-time comedian, I guess I should say, Bennett Susser, joins plaintiff Stuttering John. But so far, he's done nothing forward-facing. I have to assume that he's doing stuff in the background. Luigi, do you think that right now Tabor is bouncing stuff off of him? What do you think his role is right now?
I really wish I knew, but there's been no real reveal as to what it is because Tabor's signing everything. I'm guessing that what happened was that he's been part of this all along and then felt the need to jump in. So maybe he's already done something with helping preparation beforehand and just needed to reveal himself because it was going to come out eventually. But I don't know. He hasn't actually proactively signed anything or put his name on anything. So there's no telling. He might just be a consultant.
Yeah, that's entirely possible. I will look forward to seeing if he actually does any work, especially because I think it's very bizarre. Again, we're going to be getting into the love letter and everything that's going on now very, very shortly. Okay. But I think it's interesting that specifically with the love letter, Tabor is saying in that, well, I can't handle anything in court. Why can't Susser? Well, he's not going to be going on the trip to wherever the heck they're going with Natalie, the love of Tabor's life. So I just don't understand what his role is whatsoever. Yeah, like why can't he handle the case in Tabor's absence?
Right. Why would you have? Okay, go ahead.
No, I was going to say, I think that is a question. If we can just put a pin in that, I believe that's going to be a question that is going to be asked with Danny's latest filing.
I do too. From today, his latest filing from today. All right. Okay. So then,
I'm sorry.
the next thing
Did you have a question, Dr. Steve? Real quick. I'm sorry.
No.
I'm sorry.
Well,
okay.
No. I mean, Bennett Susser is primarily an environmental lawyer, right? I mean, I know he does business law too. So,
and Tabor is primarily a contract lawyer. Neither one of these people seem qualified to be doing what they're doing. But
interesting.
Well, that's
very interesting.
That's not an assessment I'm qualified to make. I'm just looking at his website.
Did
you say he's also a stand-up comedian?
Have you not seen any of his stand-up?
That's really him going, Susser!
Oh, yeah, that's really him.
I just thought somebody grabbed that from somewhere.
No, that is
good for him.
Oh, Dr. Steve, you got to go watch Tukey Soup and see the whole thing. I'm pretty sure that they played the whole thing. It's so good. And by so good, I mean it's literally awful. At one point he says, my favorite joke of his is, well, I'm from New York City, so I say soder, and that means I also say subpoena in court. Ha ha ha. I was like,
well, he's one of them citified comics, don't you know?
It's so good. It's so good.
I do want to see that. I can't keep up on everything anymore.
It's
impossible.
I
used to know everything that was going on in this little universe of ours. And since the Big Bang, it's just, the inflation and the expansion is impossible.
It is impossible.
It's literally impossible to keep up on everything. But anyway, I'm sorry. Go ahead.
We are so lucky that we have so much content to keep us entertained at all times. But oh my goodness, I cannot keep up. Everybody, I randomly hear things. Somebody will randomly be like, "Oh, did you hear about this?" I'm like, "Oh no, I haven't heard anything about that. When did it happen?"
Right.
"Oh, today." I don't know. It's incredible. It's absolutely incredible.
Yeah.
And wonderful. We're very lucky. We're very fortunate to have so many great creators keeping us abreast to all of the excitement.
Agreed.
And so many horrible
Thank God
creators.
for Doom. That's all
Yeah.
I'm saying.
Oh, Doom.
Doom rules.
The Reader's Digest of the Dabbleverse. That's
So
Doom.
good. Okay,
There's
so
a quote
Tabor.
for you, Doom.
Tabor also files some opposition to both of defendants' motions. And again, Luigi, you already said this perfectly. He messes it up twice. He files opposition, which means he's responding to both the motion to dismiss and the motion to transfer venue. It also includes, in addition to him messing up the filings several times, he also includes the poorly redacted witness affidavits that try to redact names but then say the names up in the top right corner. And also he includes those witness affidavits on the dismissal motion as opposed to the motion to transfer, which is where they would be relevant. But his main argument there is all about Kate. That's basically what we've gotten into with Tabor's motions at this point. She has not been added to the complaint yet, so this continues to not be a very good point to make, but that doesn't matter to Tabor. He's going to make whatever points he feels like he wants to make. I don't know what the heck he's doing. I don't think anybody does.
I don't know that he does.
Yeah, it is entirely possible. So that brings us to where we are today. And we are going to be starting out.
Can I interject one thing, which is
Yes.
I feel is important, is that there has already been, from the plaintiff, a discussion of a settlement.
Yes.
Yes, or at least an offer to begin settlement talks. Maybe that's a better way to say it. Which,
What would that tell you as an attorney before you've done anything, that you get a letter saying, "Hey, we would be willing to settle"? What does that tell you? What, as an attorney, what's that message that you're getting from that?
I don't think you have to be an attorney to get the message from it, but it basically says, let's end this now before we have to keep going because we don't think we can really see it to the end.
Yeah.
But what's amazing about his specific settlement was that there's no mention of money. There is only mention of stop talking about John, which only solidifies Karl and Shuli's argument that it is entirely within the realm of the SLAPP lawsuit. And it gets used by Danny later as evidence to suggest that it is in fact a SLAPP lawsuit to get the SLAPP certification on it.
Yeah, this might have been the most foolish filing that could have possibly existed. He really, 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 I mean, we talk about stepping on rakes all the time. This is a big rake because not only does it say, we don't care. It would just be nice to our friend. We don't want him to get bullied anymore. Not only does it say that, but it also says, the whole point of this lawsuit is egregious because we don't care about money. We don't think we suffered financial damages.
We just want you to stop talking about John. You stepped in it with this one. Yeah. They are just, again, out of control. Everything about this defies logic and explanation unless the explanation is cocaine. It is so incredibly odd and crazy. It's weird, and it's hard to describe to people who are not familiar with seeing legal proceedings all day long how unorthodox, how nonsensical, how ridiculous this is. It's not like this. And this person is really making efforts to continuously make a fool of themselves.
Can you put that back up for a second, Lucy?
Yeah, of course I can.
I just want to ask you about one sentence. It says,
absolutely.
Perhaps more importantly, give us time to discuss a possible settlement. I think this would be in the best interests of our clients. I mean, is it normal for an attorney to worry about the best interests of another attorney's client, but particularly when they're opposing each other? I'm just curious about that.
In an informal letter, I think I've seen that language before. It's not
Okay.
that crazy, but it is. It's also salesman language. They don't mean it. They're just saying,
Sure.
"I think this is best for both of us."
Yeah.
Is really what that is attempting to say, and I don't think there's really too much to really dig into that.
I've seen that language in a lot of settlement letters and settlement offers and settlement requests. I think that is standard. We are playing nice in the sandbox, Judge. Look at how nice we're being to each other. We're doing all the right things. We're saying all the nice things. We want to get this off the court's docket.
Yeah.
We just want to be able to have the nice conversations with everybody so that we can get out of the icky situation that everybody is in. And so I think that is, not only do I think that that's somewhat standard, but I think that that's canned language that Tabber is just copy pasting from somewhere else. And we all know he loves copy pasting.
Oh, yes, we do.
Oh, yeah. Well, then it says he'd like to have an amicable relationship, and then the next sentence says, "I'd like to work with you amicably." So he's very redundant in his language on top of that.
He's doing good. That might be one of the best letters he's written, and still at the same time exactly the worst.
He's making nice, so I'm always in favor of that.
Okay, so again, just talking about Tabber being out of his mind, we are going to now look at the infamous love letter that was filed by Tabber on 9/16. So this is, I don't even know how to describe it because I've never seen anything like this ever before.
It's so bizarre. I don't get it.
It's so bizarre. So what Tabber says in this letter is, "I am writing respectfully to notify the court that I am going to be traveling out of the country through October 11th to celebrate my 9th year anniversary with Natalie, the love of my life."
Yay.
The court has never cared about Natalie, and they will never care about Natalie.
Yeah.
What the fuck?
That was so unnecessary, and that was literally, if you've ever had a conversation with someone that you think is going well, and then they just say that one thing that makes you nervous to be around them. That's what that was. It was completely unnecessary to say any of that, and you
could have just ended it through after October 11th, 2025, and just that would have been the.
That could have been it, right? Or just yes. Okay, so he already mentions traveling. That's it. There you go. You think the judge is going to ask, "Where are you going?
Right.
Who are you going with?" No, they don't ask that.
Now, what struck me was it says "in part to celebrate." Oh, what's the other part? What else is he going to be doing?
Oh, it's sightseeing. He's going to hang out with some buddies. I don't know, maybe get another DWI. It's impossible to tell with him. Impossible.
Okay.
This is one of the most egregious letters that I have ever seen in my life. And I want to bring up, actually, we're going to talk a little bit more legalese, because I want to bring up specifically the court's part rules. Now, part rules are something that we have not talked about at all yet when it's come to this LOLsuit, but they are basically court-imposed regulations that are specific to the judge or the specific part of the court. So this is the judge's part rules. And again, these are those specific regulations. Each judge is going to set these for their individual courtroom because they want to say how they like things to be done. So for example, some judges might say, "I only want to hear motions on Tuesdays, and that's going to be the only day that I want you to submit a motion. Do not submit it any other day," because that's what their preference is. This is the personal preferences of the judges. So I want to look at Judge Cohen's, which is the judge in this case. I want to look at his part rules. And specifically, I want to look at this little section at the bottom here that I have highlighted, which says, "Do not copy Justice Cohen, the law clerks, or any part clerks on letters, documents, or emails exchanged between counsel. The court will not read them, and they will be discarded by the part clerk." Now, that seems to be in direct contradiction to Tabber's beautiful love letter, right? So going back to his love letter, the place where this is a little bit different is that this, of course, is directed to the judge. So that doesn't exactly fit into the part rules. But I think that the intention of those part rules is that the judge is saying, "Do not waste my time with mindless bullshit." That is the intent of those part rules, is please do not include me on any correspondence that is not necessary for me to review. And Tabber decided to include his travel abroad plans, his love of his life, Natalie. And not only that, but he's asking for adjournments when all of the motion dates had already been set at the time that he sent in this letter, and all of them were going to be after October 11th anyway. So what the fuck does it matter if you want this? The next court appearance is set for December.
Because my question was, how is he supposed to tell the court that he's going to be out of? I mean, you wouldn't send a letter to the judge saying I'm out of town for 2 weeks.
And again, that is that could be a viable way. This could have been a viable way for him to give the judge that information.
But this is meaningless because there wasn't anything going to happen between those two times.
He did it all wrong.
Yes. He did it all wrong.
Wow.
Yes, that's the takeaway. And I do want to point out also, I got a really great comment at some point from Herb Beta Patched, who said the last time Tabber said that he was going on vacation, he went to prison. Wow. Yeah. So I do just want to point that out right here. Just as an aside, I thought that was a really
here,
thoughtful
folks.
comment.
He's going back to prison.
What do we even know?
That in part to celebrate could be conjugal visits, I guess. Yes. Now, Honorable Milton Tingling, he's not the judge then?
Correct. So that is, I believe he's the county clerk or the court clerk. I can't remember exactly.
So they're honorable as well?
That is a little bit peculiar. I did look him up because I was specifically confused by that. It looked like he was actually a judge, and I'm not exactly sure why he's acting as the clerk in this particular case. But again, not only each court, but each judge kind of sets things up on their own. Am I right about that, Luigi? Is this normal? Yes. Is that not normal?
Absolutely.
Okay.
Yeah, because if you go to the document list, Honorable Milton A. Tingling has got his picture right there, and I assumed that he was.
I did not notice that.
He was at the very top of the list. It does say New York County Clerk and Clerk of the Supreme Court. Yeah. So I thought he was the judge. I didn't realize Judge Cohen was the judge. So, do we know anything about Judge Cohen's demeanor?
He seems to be a very reasonable and lovely judge. I know that Danny has cited a couple of Judge Cohen's decisions in some of his motions and letters, which has been genius, beautiful. I loved it so much. I was like, you know how to, you know what to do. You know when to bow down. And I was very impressed by Danny with that. This letter, I can't.
It's really hard to convey and explain absurdity. Like, I'm finding that when I'm trying to explain these absurd things that don't make sense, I feel like I'm doing a bad job explaining them. We really have to just convey, it's not us, folks. Yeah. This doesn't make sense. It does not make sense.
Well, maybe the practice of law sucks. That might be part of it. Maybe
that's true. It does suck.
Gentler, like Tabber is doing.
The justice system is very flawed. The United States justice system is extremely, extremely flawed. That is 100% correct.
That's what makes it difficult.
Yeah,
it is. This is the right way to do it, when the right way to do it may not even make sense in and of itself, but that's just how it is. And when you have someone that's doing something that's different than quote unquote how it is just very jarring.
Yeah, it becomes impossible. Again, it's the strings on the crazy who is the murderer board. Like that's what I'm trying to do whenever I'm trying to understand Tabber's motions, because the usual process when somebody files a motion, this is what should happen, is the motion, which is a request for relief. A motion is asking the court to review and decide on something. The normal process is that a motion gets filed and served. So Tabber did do that, or rather, I guess Danny started out by doing that. And then the other side gets an opportunity to file opposition to that motion, which is their response. And then the moving party, so the person who originally filed the motion, gets to rebut that opposition with a reply. And after that, the motions will all get what is called a return date, which is what happened just this past Friday on 9/19 when the motions were marked submitted. So what happened on 9/19? The court looked at the motions, said these exist, and then they picked them up and they put them in a different stack of papers to look at on a different day.
Wow.
That's basically what submitted means. And then we have to wait for a decision. And in this case, more than likely, we will not have a decision until after December.
Oh,
However, because of this SLAPP stuff that is going on, it is possible, and because of the letter that Danny just filed today, it is possible that the judge will put this on the fast track. We have no idea if that's going to happen or not. We can only hope that it does, because none of us want to wait until December. And I'm going to be honest with you. I deal with the New York County courts a fair amount. Right now, easy motion sequences that they are reviewing are typically taking 6 to 9 months for review. And those are the easy peasy ones that take no review on the judge's part. This is a complicated one, which is going to take a lot of review. So I have a sneaking suspicion that the judge is going to keep putting this to the bottom of the stack. I could be wrong.
When it comes to the procedural stuff, it's starting to become clear to me now, because if you watched me precepting a medical student and they are giving me a history and physical, they do, it's called a presentation. Yeah. And I could be criticizing them, saying, nope, that belongs in the subjective, this kind of stuff. And don't give me diagnoses. And you all would look at me and say, well, he's being an asshole. But there is a reason why these things are that way, even though it may be stupid to the outsider.
Absolutely.
So I think it's kind of the same thing here.
Yeah, there is a procedure that is intended to be followed here.
Right. And it's there because for 200 years, they've been fiddling with it to try to get it right.
Exactly.
And the best it could possibly be right now.
But now imagine, Dr. Steve, that instead of a medical student trying to show you that he knows what he's doing, imagine it's someone with your same amount of tenure as a doctor,
right?
And then fucking it all up, which is what we're looking at here. Yeah. And this is really crazy. It's so crazy that somebody who has experience in the law as much as Tabor has does not understand the basic procedure that is intended to be followed here.
Wow.
Would you define Luigi? I have a question about that. Would you define him as having a lot of experience with the law? Because I think the only place that I've seen him have experience with the law is on the wrong side of it. He's only litigated one case, I think, before this, and he withdrew his counsel on that case.
Okay. Great question. But the thing is, he's been a lawyer for a long time, and you have to learn this as the foundation of everything else that you learn in law school. So even though I am currently not a litigator, I do know all of this stuff because I had to learn it in law school. Then you have to spend your first couple of years, second chairing and, paying your dues essentially in the real world of learning all this stuff. It gets solidified in your head when you're doing this sort of stuff. So despite exactly what you're saying, I get it. Yes, he spent some time in prison. Maybe he forgot some things in prison. Yeah.
Or learned some things.
I think, yeah.
Can we do a moot court? Oh, I'm sorry, Lucy. Go ahead.
No, you go ahead first.
I was just going to say, why not? We should get a bunch of attorneys together and do a moot court on this based on these filings.
That would be a really interesting thing to do.
And then we could have like 12 angry dabblers, and we could do that play too as a separate thing.
I love
How much fun would that be?
12 angry dabblers.
While we're waiting for December to come around, what else is there to do?
We might as well.
Some law
We're going to have a lull.
Yes.
I think that there's something more important to consider, though, when it comes to Tabor and his ability to practice law, which is that I believe it's the New York Post who referred to him as a Gat's baby. He is a privileged kid from the Hamptons who probably did not study that hard in law school and got everything handed to him. And that's conjecture entirely on my part.
Law school is law school. You gotta.
There's good.
Right?
But okay, have you ever seen somebody who fucked off a lot in medical school? Absolutely. There, in every type of school, there are people who you want to be your doctor and who you don't want to be your doctor. In every single school, there's lawyers that you want to be your lawyer and lawyers that you don't want to be your lawyer. And I think a lot of the lawyers who kind of squeak by the system are lawyers similar to Tabor. I don't know if that's him or not, but it certainly feels like that might be a thing that happened with him, because either he forgot everything from killing brain cells with alcohol, or he is an idiot. I don't know what more to say about him than that. And I've been relatively tight-lipped about my feelings about him, but this is so egregious at this point. It is unbelievable to me what he has done with this case. It's malpractice. It's malpractice. I mean, it's insane.
That's a strong statement.
I know. I'm going crazy.
We don't like the M word in medicine.
I do agree with her. If this turns out bad for John, I think he has a case for malpractice. I literally, and very genuinely do believe he has a case for malpractice.
Really?
If this gets tossed out on a motion to dismiss and the judge writes something in his ruling about the incompetence of the lawyer and the filings, I think there's a very real case there. But also to your point, Kaylee, is that in law school, I mean, I hate to do the hacky joke, but somebody does have to graduate at the bottom of the class.
Sure.
And, there are people who just don't invest their life or change up their life in order to make good grades.
You hope, though, that the people that are in law school classes are already the cream of the crop. So if you're at the bottom of your class, you're still, you're still the cream. You're just the cream that's closer to the milk. I mean, that's what you would hope.
I don't know why, but I really dislike that.
I don't like that analogy at all.
I don't like food analogy.
It's not for me. It's not for me. All right, we're going to check out a couple of super chats. Dr. Steve, I know you're going to have to head out relatively soon. Will you hang out with us for a couple of super chats and then and then I'll let you get going? And
I
Luigi and I are
Dabble Dice.
Yes,
Dabble Dice, the game of beer disequilibrium in livers. Lucy was the first person other than me to ever play it. You collect, you can't read that, but collect beers sent by your fans. But watch out, you're unsteady on your feet, and drinking is bad for your liver. Dabble Dice at stuff.drsteve.com. This one's only $10 plus shipping, so it's a fun party dice game.
This is a super fun game to play with your friends who are dabblers and your friends who are not dabblers. Right. It is a great game. Absolutely
no prior
amazing.
Knowledge of the Dabbleverse is required. You could play this and not know anything about it.
Highly, highly recommend. I'll make sure to link that below as well because Dr. Steve, Dabble Dice is amazing. I love it so very much. When we are done with Super Chats, Luigi and I are going to start going through all of the documents that have been recently filed. Danny on behalf of the defendants, he has done so good. He filed opposition and replies to Tabber's malarkey, and we are going to go through all of those documents. But first, we will get to some Super Chats here. We have Herb Beta Patch coming in for $5. Tabber throws a hissy fit over every perceived slight. It's like being sued by an ex-girlfriend. I couldn't agree more. And also, don't you kind of imagine with the letter of saying the love of my life, Natalie, don't you imagine her kind of like standing above his shoulders being like, you tell the judge that we love each other so much and we have to go on vacation. Like that's kind of the impression that I'm getting of Natalie right now.
I'm glad he's got somebody, like I said.
I am too. I'm so happy for everybody.
Are you going to let him talk to you like that, Tabber?
I am legit glad for him. Anyway,
I love is the most beautiful thing in the world, and I'm very happy for anybody who gets to experience it.
Agreed.
Yes, absolutely. Drunk Engineer for $2. Time for everyone's favorite show in the Dabbleverse. Thank you so much.
We have the
amazing Annie over here for $2. Go to Supertip. Go to Supertip GG/Lucy. I know I need to. I'm very behind on setting that up. I have been delaying, but I will be there at some point. You're right, Annie. You're right. Also, hi, I miss you. Diz 5 for $2. Shana Tova. Shana Tova to you as well. Happy New Year to everybody. We're celebrating Judaism, which is something that Luigi and I will get into in the most recent letter from Tabber coming up soon. Big Daddy Dodo in for $2. I'm just here for the dabbling and the type boxes. I am too, sir. Thank you. Craig New York 77, $5. Thank you so much. Let's fucking go. Dr. Steve, thanks for being here. Lucy, always happy to see you, my love. Luigi, sup, bro?
Hey. What's up, Craig?
Thanks, Craig.
Craig's great.
Craig's a good one. Oh, there's
we
Sean.
Have Sean for $5. Hi, Sean. Thank you.
Sean is one of my friends who disappeared on us at the Detroit trip, at the Detroit show. Yes. Thank you, Sean. You're a good boy. He's
we have Sorcerer coming in for $5. This is by far the best coverage of the LOLsuit. Great way to relax on a Sunday. Hey, Dr. Steve, biggest fan.
Hey,
Great talk
Sorcerer.
on the net.
I got to meet Sorcerer at Las Vegas at Hackamania.
Yeah, amazing.
He's
absolutely
about 14 feet tall and very kind of a gentle giant. Good guy.
14 feet tall is a good way to describe it. Drunk Engineer, $10. I read the letter Danny submitted today. I'm not a lawyer, but it seems to me that Tabber has just been left duct taped to a flagpole in his boxers, and the girls' dance team just walked outside. Perfect analogy.
I consider that an opportunity.
Baby. Oh, Danny's response.
Danny's.
I'm in love. I'm in love with Danny. I'm in love with Danny, guys.
I'm rock hard.
I'm pretty sure that me, Luigi, Karl, Shuli, and probably Frog, probably tons of other people are all going to fight for Danny's love at some point because he's so great.
I've already offered my mother.
Yes.
I appreciate virtuosity wherever I see it. He is a
Yes.
virtuoso.
He cares, he's thoughtful, he knows when to push the court and when to be professional, and he's done such an excellent job of being both snarky and extremely professional, and it's truly, he is a master. I can't say enough good things.
I love structure, and his mastery of structure is really off the charts and very impressive.
Awesome.
He really is. Next up, we have Hunter Duke. Happy belated birthday, Hunter Duke, for $5. Legal Talk just got 200% more sexy. Thanks, Dr. Steve. Thank you, Kaylee and Luigi, for keeping us updated on this train wreck. Hunter Duke is absolutely incredible. Everybody loves Hunter Duke. I wish I was wearing my Hunter Duke shirt right now. He gave
me
two
as well.
shirts in Detroit. Yeah.
He's the king of shirts.
He is. 2 short long dogs for €2. Dr. UK loves to please say fluid.
Fluid.
Lucy, sup, Luigi. Give him one more. I messed it up.
Pustulence.
What's up, 2 short long dogs?
Tumescence. There you go. That was good.
Everybody can listen to that all day, Dr.
The
Steve.
reverb work, I'm just curious.
It did.
It
Okay,
did.
okay,
It
thank
did.
you.
It was beautiful. It sounded like you were in a, I don't know, echo chamber. That didn't
Sound like
make
I had
any. I'm gonna
reverb on
stop
my
saying
voice.
words. Yeah, it sounded like you had reverb. I tried. All right, I'll stop saying words now. Jay Wolfenstein for $10. Thank you so much. I can't take this 3D virtual avatar coward seriously on legal matters. If were a legit 3D virtual lawyer, we'd have 3D virtual lawyer T-shirt, and he clearly doesn't. Liar, coward, boo. All right, there he is.
Thank you,
He's
Jay
back.
Wolfenstein.
He's back. Ugh. Silly Luigi forgetting to change his shirt today. Zom247 for €2. What would Myrtle say? Myrtle comment.
She's on the wall behind me. Well, that old Luigi, he's a pretty good fella, but I don't know much about that old Lucy, I tell you.
It's perfect. It's so perfect.
Myrtle never says anything of any import whatsoever. See a penny, pick it up. All the day you'll have a bright, shiny penny you could buy penny candy with back in the Depression, but they ain't got that no more, you know. Oh, well.
There's no penny candy anymore.
No.
No penny candy.
Yeah, she
the Edgelord for $2.
Things. Go ahead, sorry.
Thanks for saving me from my beer at DabbleCon 1, Dr. Steve.
Don't know what that's about, but you're welcome, my friend.
It sounds like you did a great job, Dr. Steve. I'm unsurprised.
Oh.
Gold Fool, $10. John is suing 2 homeowners plus a girl with a rich mother. John can take their homes. If John loses in counter or others, Karl and Shuli will get bubkiss. So right now, John is not suing any girls because Kate Meany has not yet been added to the lawsuit. He wants to sue a girl, but he has not yet been able to do that. And it is true that John, because he is a degenerate loser, has a lot less stake in the game because if/when he loses, it will be much harder to recoup the losses for Karl and Shuli.
Can I ask you about that? So Karl and Shuli are part of the lawsuit because they
Yes.
filed a motion saying, or whatever, they filed a complaint. So how is Kate Meany not part of it? How come you can't just send something else in and say, okay, now it all has to be in the original complaint, and if not, then the judge has to approve it? Is that how it works?
You want to rock, paper, scissors this?
Well, I just pulled up. I'm going to explain just the caption here, and then I'll have you have you take it from there. So the document that I just pulled up a random document, and you can see up at the top in the left-hand corner there, it says plaintiff John Melendez. So it says John Melendez, comma plaintiff versus Karl Shuli, the Shuli Network. Who are these podcasts? And then it says defendants after that. After you have chosen who is in that caption, after you have made the defendants known, you can't just add new defendants. It would be the equivalent of me saying, let's say, Dr. Steve, let's say you and I get into a car crash today, and it's my fault. And so you sue me, and you say, I'm suing Lucy Tightbox. Okay. And then a month from now, you decide that another car actually caused me to crash into you. You can't just add that other person. You can't just add Joe Schmo randomly at any point because the lawsuit has already been commenced. And lawsuits are very sacred because they're through the judicial system. So we have to make sure that everybody is aware of them. We have to make sure that everybody has time to submit legal defenses. Luigi, I said more words than I thought I was going to, so I'm going to have you take it from there.
That's a great answer.
No, it's okay. But to add to what she's saying is she's right about everything. There are ways to add defendants procedurally. They just messed it up. They're allowed one amendment to their lawsuit, but they used up their one amendment to correct the spelling mistake of Tabor Benedict's name.
Oh.
So they submitted what is called a motion for leave to add this other defendant, Kate Meany, which by leave, it specifically means please grant me
violate the rules.
Something that is outside of procedure.
Oh, now it's all making sense.
And now they are waiting for the judge to approve Kate Meany as a defendant. Yes.
So it's like the genie, and you use up one of your
wishes. One of your wishes. Yep. Yeah.
Wishing for, I don't know, I wish I'd known about this before.
Yeah.
Right.
I like to think of it as when Homer takes Apu to the Quickie Mart in India, and he says, "I'm going to give you 3 questions," and he says, "Are you really the head of the Quickie Mart?" And he says, "Yes." Really? Yes. That's 2 questions.
Right.
Yes.
Okay, I got it. That's a better example.
Yeah.
Yes. All right, we have Craig New York coming back in for another $2. Will SJ still want to be a lawyer when he loses?
Yes.
Mm-hmm. Yeah, I think he's set on that at least for a minute.
Yeah, I could have done a better job.
Yeah, I know, right? Beef drippings for $2. Yo, what up, nerds and amazing Dr. Steve's fluids.
Beef drippings.
I can't do it.
You get corn squeezins and beef drippings. That makes you a good Saturday night.
Next up, we have the incredible Adam Bush. Thank you so much for the 50, Adam Bush. Greatly appreciated. John sees this lawsuit as another national news garnering accomplishment, like the failed Trump prank call. He doesn't care if he wins or loses, only that his name appears in the press, and hopefully Howard sees it. Great show.
Thank you, Adam Bush.
I think that's an interesting theory. I don't know that I fully agree with that. I think his ultimate goal is to get Karl and Shuli to stop talking about him.
I believe this is an element of his motivation.
Yes,
I definitely think so. Yeah.
And we haven't really talked about that at all. However, we will talk about the failed Trump call because that does get added into some of the motions, and I'm very excited to start talking about that. So thank you again, Adam Bush. Super, super appreciate it.
Thank you very much.
Everybody make sure to listen to Adam Bush on Who Are These Podcasts on Wednesday night, every Wednesday night. Anthony Zenhauser, another heavy hitter coming in here for $5. Who's that old fart? Ira Chuckleberg? Love you, Dr.
Ira Chuckleberg.
Watch your ass, Luigi. Hashtag fart jar.
Fart jar, yeah.
Awesome.
Luigi's favorite attorney, Ira Chuckleberg.
Ira Chuckleberg. I plan to open for him one day. Thank you, Anthony. That's awesome.
Thank you so much, Zen.
Hashtag fart jar.
Yes. And we have another heavy hitter coming in.
Where
the
have you
Bologna
been?
Factory. I know, right? He's posting stuff right now. He's got some funny stuff on Twitter.
Okay.
Everybody go check out the Baloney Factory.
Okay.
He's not doing as many animations anymore these days, or at least not that I've seen, but he's got some good stuff up on Twitter right now, all related to this case. So highly recommend. $20 Canadian. I'd like to this is quote. I'd like to submit a motion to vacation Cabo, 2 weeks, end of September. My wife doesn't respect me. It's effectively the letter that we are reading.
That's great. I love that.
Oh my God. He's so talented. The incredibly, incredibly talented Baloney Factory. Big fan for $5. Luigi, how old was the oldest student in your law school? Is the LSAT easy?
First off, LSAT is not easy. It is not. The oldest person was actually...
you.
That's true. The oldest person was probably in their early 50s. I'm going to say maybe 52 was the oldest person in my law school class. But
Alan
here's the thing.
Stewart was the world's oldest law graduate at age 91.
Oh, boy.
Yeah.
But here's the thing, as I'm going to tell you, please do not dignify John's law school stories about going to law school, because it's just not going to happen. He doesn't even pronounce it accurately. He says LSATs as if there are multiple tests. It is the law school admission test. That's it. That's all you have to say. But also, you have to take into account that you have to give a lot of documentation to get into a law school. And the combination of being 60 and a D student in high school is not going to open a lot of doors for John.
Holy shit. The scale is only 60 points. It's from 120 is the lowest to 180 is the highest score on the LSAT.
Yep.
Holy shit. There's not a lot of differentiation.
Nope. It weeds everybody out.
Well, it sure does.
So he would have
Almost everybody.
almost
60
everybody.
points.
Yeah.
Spread,
So
that's it.
So he would have to make a decent grade, not like John says, pass the LSATs. Fucking idiot. You have to make a decent grade on the LSAT, and then submit applications to law school with all of your background information. This just isn't happening, folks. This is science fiction.
Wow.
Yeah.
The SATs go from 400 to 1600, so there's a lot of differentiation there. That's crazy. Wow. I'm going to take the damn LSAT now.
You would probably do very well.
What do you have to know? I mean, it can't ask you legal stuff because you never went to law school. So what kind of stuff is on it?
There's a reading comprehension section, which instead of like what you see in high school, it is very, very poignant reading comprehension. It asks very specific questions. And then also logic is a big part of it. So all you can really do to practice for the study is take other exams and kind of understand what it is they're looking for as far as the answers. And I'm going to tell you, a lot of them in hindsight, I thought were kind of ambiguous. Like I was like, no, I think my answer was right. Yeah. And they would still tell you, no, it's not. And there's a lot of that. So
not the best answer.
Exactly. It's not the best answer.
I'm going to take it.
I would love to see the results of that, Dr. Steve. I would be very happy with that.
Okay.
Dr. Steve, I know that you have to head out soon, but before you go, I want to just show you one more super chat that we have here. And then I want to make sure that you have time to, again, talk about Dabble Dice and where everybody can find you. But I want you to see this one in particular because I really, really love it. Jeopardy Ace, thank you so much for the $50. 12 angry dabblers. Dr.
How much
Steve
fun would that
for
be?
the win.
That's great. It is really great.
I'm just going to tell Rocco and Cardiff we had an idea for Hackamania 3 and we're changing what we're doing. This is it.
This is the way to be. I love it so much. Dr. Steve, please tell everybody where they can find you, how they can get Dabble Dice, and all of the exciting things going on.
Oh, there's nothing exciting going on. I'm no longer on SiriusXM, and I had the idea I would do all kinds of YouTube stuff, and I just have not found the time yet. But it's going to happen. But the podcast is still going wherever podcasts are found. It's Weird Medicine. And just go to drsteve.com and it'll lead you everywhere you need to go. And then Dabble Dice can be found at Stuff www.drsteve.com. And I think you have to spell out doctor, but I'm not 100% sure. I need to check that because I've got the Dr. Steve and the Dr. Steve domains, and sometimes I'm too stupid to link them all together. But anyway, listen, I have really enjoyed this. This, as far as a LawTube show, is by far my favorite. And thank you for asking me to be on, because I had so many questions. You guys are so good at explaining these things. I have a lot more clarity about a lawsuit that, honestly, I have absolutely, it's just prurient interest at this point. But it is fascinating. So thank you.
So glad to have you.
Thank you.
It's a true honor to have you. I appreciate you slowing Luigi and I down when we're getting way too into the weeds of the legal mumbo jumbo. So thank you so much for coming to join us. And everybody go get Dabble Dice. You're going to have so much fun playing it. It is a blast. I can attest to the fact that is a fun game you will enjoy. And
please let me come back sometime, because I really enjoyed this.
You are always invited. I hope that you have a wonderful rest of your Sunday.
And you do as well.
Thank you so much. Have a great
Thanks, everybody. All right.
Yes.
The legend, Dr. Steve, folks.
The absolute incredible guy. Let me read just a couple more super chats here, and then we are going to get into these motions. I know we've been doing a lot of super chats. We appreciate your guys' support so much. And also, do not forget to go support Karl and Shuli. They both have Patreons. That is a great way to subscribe to them on their memberships on their channels. Support them in any way that you can right now. Rumpled Trenchcoat at Columbo Podcast, $5. Serious question: does SJ have a legitimate malpractice suit against his lawyer? Luigi?
We talked a little bit about this, and I think so. Especially if this gets kicked out because of Tabber's incompetence. What's going to happen is there's going to be a written decision on this motion to dismiss, and if in fact it gets dismissed and the judge cites specific reasons having to do with Tabber's inability to follow procedure, and bombarding the court with all of these filings, I gotta say I think there's something there for John. I really do.
Yeah. Well, we'll see. He's not a big fan of actually filing lawsuits, despite the fact that he actually did this one. We've all heard him.
But he has to be damaged. That's the thing. He has to be damaged in some way. But yes, but I'm saying for a legal basis, for a lawsuit, he has to incur some kind of damage. So we'll see. Yes. Jury's out.
Donnie699, $10. Thank you so much. Great job, guys. You are forgetting one major thing. This smells like Vince the lawyer from 1,000 miles away, and I'm sure he has some New York judges in his back pocket. That is a terrible fear.
Yeah. No, we've mentioned Vince before, and we definitely think that these two were connected. By these two, I mean John and Tabber were connected through Vince, and I believe to some extent it's been acknowledged. We definitely know it. Unfortunately, we can only speculate as to what the involvement is after that, and because we don't know is the reason we don't mention it. So,
Tabor Beneduc, $5. Thank you so much. Miss Tits McGee and Mario's Hebrew brother can expect a cease and desist. Dr. Fingerbum too. Ah, yes. Wonderful. That makes so much sense.
It'll be the second time I fight a duck in court.
We need to start getting into more of these documents because boy, oh boy, are there so many of them. So what has Danny, on behalf of the defendants Karl and Shuli, done now? What has he done? He has filed opposition and replies in response to Tabber's crazy malarkey that is completely insane. So first we are going to be looking at the reply in support of the motion to dismiss. So the defendants here, Karl and Shuli, say that the lawsuit is baseless, contradictory, and really just an attempt to shut them up. And they want the court to dismiss this lawsuit based on that. So we're going to go ahead into this document here. And what we're going to see is defendants Karl and Shuli saying, listen, we already have our motion to dismiss out there. We want the proceedings to be stayed because of the SLAPP stuff. We want to recover fees and costs. And in addition to that, we're going to respond to John's opposition papers and affidavits.
Can I add something real quick, which is,
yes,
this is procedurally accurate. And according to procedure, Karl and Shuli's lawyer is entitled to file a reply to Taber's response. That is very typical, that is normal, and that is prescribed by statute. That is typically how it goes. There is a motion, a response, and a reply. I feel like that's going to be important for as we go further. So that's it.
Yes, that is a very, very good point. Now, what does this document say? It basically says John can't sue in New York because he lives in Florida. It says that the plaintiff, John's evidence, is inadmissible or false because it's hearsay, duplicative, it's irrelevant, all of these things. It says that the affidavits sworn to by John and his witnesses include lies. They're perjuring themselves.
Mm-hmm.
And it also describes what we've already talked about when it comes to that settlement letter, which is that the settlement letter admits to the SLAPP intent. The plaintiff, John, is admitting to the fact that he would drop the lawsuit if Karl and Shuli would just stop talking about him. Which is
all
crazy.
correct. All correct.
The last thing that it talks about a lot of things, but in addition to that, it also says that John is a hypocrite because he has done exactly what he is bitching about Karl and Shuli doing when in 2018 he prank called and secretly recorded Donald Trump and then broadcasted that for profit, which is exactly what he is accusing of Karl and Shuli doing. So I've pulled up a couple of just portions of this that I thought we would go through. Luigi, please feel free to stop me if you think that there are things that are relevant that I am skipping over here. But we got some excitement in this affidavit in support of the motion to dismiss. So let's go ahead and get into it. The first thing that we have here is, again, this is saying that the evidence that the plaintiff does offer is not competent, it's inadmissible, and it's hearsay. It's lacking foundation, it's unauthenticated, and it's irrelevant. And I think that is specifically referencing the couch cushions, which are so incredibly irrelevant here.
And the phone calls. It's just not it's not relevant to a right of publicity claim, but they spent so much time on it. It's unbelievable. Still unbelievable.
It's unbelievable. And again, why is Danny even bothering to take the time to respond to things like this? The answer to that is because he needs to. The defendants need to respond to every single allegation, because if they were to lay silent, then it might look like they are just accepting that information as fact. And they obviously do not want to do that. So the reason that Danny keeps responding to all of this crazy, irrelevant stuff is because if he doesn't, it looks like he's agreeing with John, and he's not.
And we've talked about the concept in legal arguments of opening a door, that as soon as you say something that you are alleging to be a fact, you are submitting it under a microscope to be analyzed from every direction in order for it to be countered by the opposing party. And by simply, if John were to just simply say, in here something ridiculous, like, I'm 6 feet tall, well, you have to address it because John opened the door to it. And it's going to lend itself to the argument, the relevance, and also his credibility. So that's another reason why you have to address every point. But yes, this lawsuit has nothing to do with tapes. That is completely irrelevant to a right of publicity claim, but they spent so much time talking about it, it has to be addressed by Danny. Yeah.
Yes. It does. And Danny does a great job in this paragraph too here, explaining why everything that John and Tabber for John on behalf of John is doing is so incredibly egregious, because he is describing that Melendez is submitting multiple identical affidavits from his friends who say that they personally believe that Melendez didn't mean to say that he had published a video consenting to all of the recordings. So these are, of course, referencing the recordings that Kate Meany did, the tapes, everybody's favorite tapes. And John just says, well, no, I didn't mean any of that. It was just sarcasm that I admitted to the fact that I knew that I was getting recorded. Of course, we've already seen that Danny, on behalf of Karl and Shuli, actually submitted video evidence proving that, in fact, he did know that the tapes existed, that they were a part of everything, that he knew he was being recorded, that he hoped that Karl and Shuli played it.
And he was going to play along and give fake information. And also what I'd like to add in there is that even though we've talked about the tape itself, or the video, I'm sorry, the video itself being from John, what John countered was that it was done after everything had ended with Kate, and that he was only doing it to save his dignity. What John doesn't realize, or at least just didn't consider...
I just want to point this out. He's using the steel toe defense. I just want to point that out. He's literally doing the steel toe defense, which is hilarious to me. Art imitates art. It's just beautiful what we have going on here in our little universe. I'm sorry, continue.
No, you are absolutely right. But what John doesn't realize, and Danny made a great point of this in the counter, and I loved it because he waited for it, he had it in his back pocket, was... Okay, now John is saying a very different story than what was on the video. Okay, well, let's take into consideration that maybe he's telling the truth and he did this for dignity. But the date attached to that video and the date of the tapes don't line up for John's story. Nope. He did it and continued to talk to her, which completely eliminates John's argument.
And one of the other things that this affidavit in support of that motion to dismiss, or the reply, and this reply here that we have from Danny, we are going to see soon that there is an additional video from 4 days after the video that we've previously seen. So there's the December 16th, 2024 video, and now there's the December 20th, 2024 video. So we're going to look at that video in a minute. But before we do... I know, it's amazing. It's just so good. There's so much goodness. It's amazing. It's amazing. Okay, so I do want to just draw attention to this line because I love it. This is where Danny is trying to describe to the court how procedurally incorrect Tabber has been, because he keeps relying on the second amended complaint, which is not yet granted. We don't officially have that yet. And so Danny says the court should consider the complaint, not what the plaintiff wishes was in the complaint. And that is what I love about Danny so much, is that is the perfect amount of FU while still being professiontional. It's so good.
Now, I know we haven't gotten to it yet, but I think this is a good time to say it, is that we're going to talk later about the newest letter, but I'm telling you, this line that he said is just so beautifully snarky.
Yes.
I regret sounding critical. I love that line so much. It's so beautiful, and it's exactly what you're saying. He's being a little cunty.
That's such a teensy bit. If I had to do it just a little bit, I want to do it just a little bit. It's so good. All right, we're going to continue on. So again, this is talking about the plaintiff denies that this is a SLAPP lawsuit, but then inexplicably filed this letter with the court offering $0. This is all stuff that we've already talked about. The plaintiff isn't serious about the $800,000+ in damages he claims, and that this was a strategic lawsuit designed to intimidate the defendants into silence. In other words, this is a SLAPP lawsuit.
100%.
It's beautifully written. It's beautifully concise. Everything is amazing. And in addition to that, this details that the plaintiff submits numerous affidavits where the defense counsel does not understand why the affidavits are being submitted. They are inadmissible. They're hearsay. They're lacking competence. They're cumulative. They're not credible because they are all identical to each other. What Danny is referencing here is these affidavits that were submitted by John's witnesses, of whom we know who most of them are because because Tabber did such a bad job redacting them. But most importantly, Danny continues, they are totally irrelevant to oppose the issues raised by defendants' motions. This is not at all part of the case, so we don't understand why we're going over it. Why are we wasting our times here?
Those affidavits are if you could make art out of stupidity, that's what they were. They were such stupid art because they defy everything that they are typically intended for. An affidavit is supposed to state
Facts.
true facts from the perspective of the person telling them. What they are not supposed to do is, in fact, violate a very specific rule of, of a court, which is to just talk about what they heard somebody else talk about, which is specifically designated as hearsay and prohibited to be used as testimony. They're useless. Yeah. These are all useless. And not only was it useless once, he decided to cut and paste and then have 3 other people sign this useless form, wasting everyone's time and very possibly subjecting all of them to perjury.
To the penalties of perjury. Now, they shouldn't have signed those affidavits if they did not agree with the information in them, but that's a whole separate story. I love Danny's first example of why those affidavits are incorrect. He says, Melendez attests that in, quote, mid-2024, I began to learn that individuals associated with defendants Shuli and Karl were exploiting my identity. Danny states, this is a false statement. Plaintiff has known for years that defendants engage in satirical commentary and criticism of the plaintiff. That's the perfect way to start out. This is a lie. It's a lie. He didn't learn that in mid-2024. Every single word in that affidavit could be considered to be perjury because it doesn't make any dang sense.
It's unbelievable. I'm going to keep saying the same word over and over because there are so many parts of this that are unbelievable.
It's unbelievable. It's unbelievable. In paragraph 16 here, Melendez's next statement is so demonstrably false, it is troubling. He attests, I have text messages that prove I was unaware of being taped and recorded.
That's the one that blew my fucking mind last episode. I cannot get past that one. That is crazy. How do you prove a negative? Scientifically, how do you prove a negative? You can't.
It's completely crazy.
It's impossible.
And Danny explains this is the exact opposite of what he said in his 12/16/2024 video.
Yes.
And the quote from that video is, I also have text of me saying, I know you're taping me. That I can prove as well. In addition to him saying he's known since the beginning, I ended that sentence really weird. Continuing on, Melendez veers into statements that are not only immaterial to opposing the motion to dismiss, but they are completely inadmissible as evidence. Melendez says that he has these text messages between Miss Meany and me after the second time I was unknowingly recorded. I have text messages to show that Miss Meany admits to giving tapes to Egar based on pressure from Egar and threatened Miss Meany, with public disclosure of a romantic relationship they had. Melendez's descriptions of the content of text messages from other people are wholly inadmissible hearsay. That is not what you put in an affidavit, my man. It's not.
Let's talk about what is typically in an affidavit. Someone's name. No, I'm just saying like typically someone's name, their birth date, facts, the day that they started a job, what they specifically saw with their own eyes, what they can say happened in a situation that they were involved with, their personal firsthand knowledge, facts. Not this shit. Not what you heard someone else say. Not what you think someone's feeling.
What you feel. My feelings. I just feel like this is not right, Judge. I just feel like it's not right. I just feel it.
As a matter of law?
Yeah.
Wait a minute. Hold on. Maybe we're wrong. Maybe there's a New York law out there that says if you feel like something's not right, you should be granted a judgment in your favor. Maybe that's out there and we just don't know about it.
It's possible. You don't practice in New York State, and I as a paralegal, there are plenty of laws I don't know about in New York State. So who the heck knows?
Maybe there is also a law that says that if you hold your breath and put your fingers in your ears and start stomping on the ground and then throw yourself on the ground, you get a win. Maybe.
Yeah, it's true. It's true. We have no idea. And again, that's exactly what paragraph 23 here states. Danny is describing Melendez states that he, quote, strongly disagrees with the motion to dismiss. His personal strong disagreement has no bearing on the court's analysis. It has no bearing. There's no relevance to that. That makes no sense whatsoever, and it has nothing to do with anything that we're talking about here.
Look at that picture. Do you think that picture was picked on purpose?
I got to tell you, congratulations, Clay, because Clay, you've made it, my man. There's been a lot of people who have made it because of this lawsuit. I think Tukey more than anyone. Tukey has been in everything. There are pictures of him one of the court documents. He got his pictures in one of the court documents. He got the New York Post article. Tukey's really made it. But Clay, you're on the map now too, buddy. Look at this. And the reason for that is because the next thing that Danny goes in to describe is that there is a new video. So initially, Karl and Shuli provided evidence that John knew he was being taped. And then in response to that, John said, well, no, that was just sarcasm. I was just trying to make it so that I didn't look like a dweeb on the internet. That's not real. I didn't really say that. And so in response to that, Danny, for Karl and Shuli, has introduced a new video. He's gotten to respond, and he gets to introduce this new video as a part of that. And he says here, a newly obtained video further establishes that Melendez is making knowingly false statements in his affidavits about not consenting to the phone recordings. So I do think that we need to check out this video. I'm going to pull it up. We have it in a couple of different parts because, oh my God, it's just too... is almost too perfect. We already had that perfect video evidence, but here is yet more.
I don't even care if she was taping me or not because it wouldn't matter.
Don't matter now, does it?
It doesn't matter at all. It doesn't matter. Plus, I would say shit just to be over the top, like crazy.
Yeah, outlandish. Yeah.
Because and she doesn't know this, but I'm sure she'll understand. I made a video last week with the date, and I made a bet on Hard Rock Bets. And in the video that I have with the date, so you know it's all legit, I say, I know she's taping me,
So that right there, he's describing the previous video that we've all already seen at this point. And he's describing it so perfectly to Clay. He just wants Clay to understand what he is doing. But he's just damning himself further and further.
Saying the craziest fucking shit because I don't care. So,
John, it doesn't matter. Like I said, you didn't come out of that looking bad anyway, mate, to be honest. And I said that from day one. You came out smelling like roses.
It didn't matter to me because I really do care about this person. I always have. Always have.
And he always will.
Words are just not John's friend.
No, they're really, really not. They're absolutely not. He's trying so hard, though. And again, I think he just loves Kate so much. So we're going to continue along a little bit more. The entire video, you can go watch the full video. I've pulled some certain sections of it, but I believe that this full video is actually about 5 minutes long. So let's check out another portion of this where John he loves Kate so much. He loves her so much that he wants to include her in his lawsuit now.
And we just been talking for the last 3 weeks or, ever since. And then I thought that it was all Dustin was convinced that she was taping me and was like, she's taping me. I'm telling you, I saw it on Reddit. Just do it. Wait. And this person, was taping me. That's what people were saying. But I didn't care. I don't care. Look, anything I would say, like I would say, I want to take you to Paris on the Eiffel Tower and bang you on top of your parents.
I hate that I had to listen to him saying that he wanted to bang her on top of the Eiffel Tower multiple times in my life.
I did vomit.
Yes, that makes a lot of sense. You had the correct reaction to vomit,
but
as a response to that. It's
it's just interesting because there's two like major things about that, which is, it's so funny. There's a real dichotomy here, and I'm sure you have to deal with this too, is that when you start trying to explain the argument about the tapes, but the other side of your brain still wants to say it has nothing to do with the point of this case, like that's what's going on in my brain, in which I want to focus time on this, but I think, oh wait, this doesn't matter because it has nothing to do with right of publicity. But this goes to John's consent. John consented. That's the fact of the matter. He consented during, he consented after. So that's really all you need. And maybe we can just get past this and we can focus on the right of publicity.
Oh my God. Do you really think that we're going to be able to be that lucky? Come on. There's absolutely. No. In fact, the next section that I have highlighted here talks about unqualified witnesses who lack competence to testify. That's the perfect way to describe all of the things that are happening. We have unqualified everybody and lack competence. We're seeing an awful lot of that. Yeah. Awful lot of that. In addition to that, Danny here is discussing these affidavits again, and he's saying, don't forget, all of these affidavits are identical. The court can question their veracity if every single witness's observation is the wholesale copy and paste job. How could all of these witnesses seen exactly the same thing is the point of this sentence right here.
How is Aussie John's mom, but also a longtime friend, as stated in the affidavit?
It sounds like you've had a really bad relationship with your mom if you're not friends with her.
Maybe.
Come on, Luigi. Come on.
I don't know that she'd ever introduce herself as my friend.
Your longtime friend.
My longtime friend, yes.
That's not how you introduce your mom to everybody.
I believe also his brother-in-law is quoted as being a family member and longtime friend also. It would have to be because it was cut and pasted. So, yeah.
Yes. As we continue along here, we can see the SLAPP suit is meant to intimidate and silence defendants by forcing them to expend money and time in defending the lawsuit, thereby abusing the litigation process for an improper purpose and engaging in frivolous litigation. That is what we are continuing to see here again and again and again. And it's really upsetting to see that. And it's upsetting for me to see my friends Karl and Shuli having to go through this.
I agree. These are my friends. I hate that they're going through this also, and I want to help, and I want to spread the word of what they are going through because this is absurd. It's just absurd.
Yes, it is. It truly is. Go support them. Go support Who Are These Podcasts and the Shuli Network. Support them. Like and subscribe to their channels. Give them money on Patreon if you have it. Anything that you can do for them right now is very, very helpful. And I think that they really need it. I think that they really need it. They're going to be fine. Everything's going to be great. I love them, and I'm very sad about everything right now. All right, let's continue with this because, again, we're talking about the largely copied and pasted and irrelevant texts. The defendants and the court are therefore forced to sift through redundant, cumulative text. For example, the memo and the plaintiff's other numerous filings simply repeat the first amended complaint's allegations about Melendez reporting to the FBI and LAPD the events of DabbleCon 2 and Dabble House, and that someone, not defendants, took his discarded trash in California. We have to continue bringing up the dang stupid trash. None of this is relevant to the issues. And we have said that so many times about this. We've said that it's so many times, but it continues to be an issue because we are wasting the court's time. We're wasting everybody's time on this crap at this point.
Yes.
It's so challenging. In addition to that, this talks about the fact that it is unclear whether plaintiff is relying on the First Amendment complaint, which is permitted because that is part of the court record, or the Second Amended complaint, which is only theoretical right now until the court actually grants it.
Yeah. And this is, just to clarify what you're saying, is this is where you're talking about the Second Amended complaint in which they included Kate Meany, but they addressed all of the other motions that they were filing in response to Karl and Shuli's motion to dismiss as if it had already been granted. big mistake. You will
Huge.
piss a judge off bad by assuming their decision on that. And then that's why they had to resubmit and then resubmit again because they fucked it up a second time. But what Danny's pointing out there is really kind of shining a spotlight on, Judge, did you notice that they assumed your decision already? Which, again, a little cunty. But so good. So good.
So good. I have to say, though, this is my favorite section of this document here. This says Melendez himself has done what he now alleges is illegal.
Yep.
Plaintiff cannot possibly allege that defendant's broadcast of his alleged surreptitiously recorded phone calls on their podcast is a violation of his right of publicity, because one of Melendez's infamous shticks is surreptitiously recording celebrities' phone calls without their consent and playing them on his podcast, which he does for profit. Hypocrite, we're doing that now. This is the legal equivalent of hypocrite.
It's exhausting. It's exhausting how incredibly transparent John is, because this is something he's so proud of. And also, if you look back on his work on Howard, so proud of being a I guess you'd just call it proponent of the First Amendment and trying to say irrational things, or enraging things to celebrities, piss them off, bust their balls. But now it's not fair when it's done to him.
Yeah, the poor little baby. It's
Transparent.
It's so challenging. I do also love my other favorite portion of this affidavit by Danny, Karl and Shuli's attorney, is how he ends this. This is his actual affidavit, and he ends it by saying, "This is not a serious lawsuit, and the plaintiff knows it." Boom,
I would have added
mic drop.
I mean, just like fireworks going off with that. It's great. It's so great, and it needs to be said. It needs to be said directly like that. And he does such a good job. I might have added a few more transparent.
Well,
in there.
Listen. I think Danny's doing a great job. You never criticize Danny again, dang it.
No, I'm not criticizing him. Think if I did.
Yes, this is the perfect way to end a document like this, because it is concisely explaining all of the points that have been made within this affidavit already. And it is so important to very clearly state for the judge how egregious and insane all of this is. I think the judge would see that even without Danny's very clear and concise statement at the end here, but that doesn't mean that I don't love that he said it. I think it's just absolutely stunningly beautiful. Stunning.
Yeah, exactly. Right? I mean, I think I called it earlier, beautifully brutal.
Yes. Yeah. That's great. That's a very good way to describe it. And basically, with the summary of that document is that the plaintiff's affidavits, so John's affidavits and all of his witness affidavits, are riddled with contradictions and falsehoods. The case is frivolous because of SLAPP.
Procedurally incorrect.
Procedurally incorrect. It's intended to silence the critics, and the complaint should be dismissed. The stay should be upheld because of the SLAPP stuff, and fees and costs should be awarded. That's basically what we are trying to say here. Now, that's not the only thing that Danny did. Danny had to file several other pieces of opposition. So the next thing that he files is the opposition to plaintiff's cross motion to amend. So remember, Tabber, for some reason, filed a cross motion to amend, which makes no sense whatsoever. He tried to correct it a couple of times. I honestly don't even know if at this point he's gotten it right. But regardless, what Danny is doing is right here. He is opposing that motion, which is what he is procedurally supposed to do. And the defendants in Danny's opposition here are going to argue that the amendment in order to add Kate and include Florida law is futile, it's improper, and it should be denied.
It's not legally sound.
They
are literally, very literally arguing issues that are not up for legal debate or for legal argument based on laws that don't exist. I don't. It's sad. It's sad that it's even made it this far. But I feel like we do need to kind of let people know that their eyes aren't on these sorts of things this early.
Yes.
Anyone is allowed to sue. It is in the courtroom when the validity of the lawsuit is actually examined. I could sue a flock of birds outside and submit it to a court, but until it is actually looked at by the judge, is it analyzed? And so I keep getting asked a lot, why is any court entertaining this? The reason is because this is the way our legal system works, and human eyes have not looked at it yet. You are allowed to sue a space monster if you want. It is only until the human eyes get on it that the validity of it, the credibility of it, entertaining it is really put on display. And unfortunately, that's where we are.
And it will probably take a long time for those human eyes to be put upon it. Although, again, Danny has requested that happens sooner rather than later. So you never know. But I do think it's quite likely that it will be a very long time. So let's go through this document a little bit and let's see what sort of arguments Danny has made here. There will be another video introduced in this document. So we're going to get to see yet another video in support of Karl and Shuli's arguments, which, again, I just love it when we get our videos because John does nothing but step on rakes himself. So we're starting this out. We are talking about the first filed CPLR 3211G anti-SLAPP motion requires an automatic stay of proceedings, including plaintiff's cross motions. So the court will first have to decide the anti-SLAPP motion to dismiss based upon the First Amendment complaint before deciding the cross motion to amend. Now, this is what we were talking about with Dr. Steve earlier. What this is saying is that because we have filed this anti-SLAPP motion to dismiss, the court procedurally should not look at any other motions until after that is decided. That is procedurally what is supposed to happen. There is what is called a stay in place until that motion is decided, which means everything else halts. Everything else is supposed to halt. So why in the heck is Tabber still filing documents?
I don't have an answer.
There's no answer.
Let me tell you,
in the last 10 days, Tabber has filed documents 8 of those days. He filed documents on 9/11, 9/12, 9/13, 9/14, 9/15, 9/16, 9/18, 9/20. What is happening?
Based on what we know of Tabber and his love of filing,
he loves filing things.
I'm actually gonna speculate here a little bit and say that because of the thing that he sent to the court, I want to make it clear, it was not a motion. It was a letter. Yep. The letter that he sent to the court and Danny's response, I think we can expect another filing tomorrow that is going to be a reply to Danny's letter. This just seems to be his MO, and it is a very, very bad precedent to set this early in the case. This is insane. This is a circus. This is so out of control.
Oh, yeah. It 100% is. It truly is. All right, let's continue along here. So what I love about this particular document is this lovely handy-dandy little table. Now, we listened to last time that we were on the 12/16/2024 Melendez video, and this table specifically calls out all of the probable lies in John's statements within his affidavits, and it specifically goes back and forth between the affidavit and the Melendez video. So in his affidavit that John swore to under the penalty of perjury, he states, in 2024, Miss Meany, whom I considered a friend at the time, secretly recorded multiple telephone conversations with me without my consent or knowledge. And then Danny lays that out perfectly in comparison to the 12/16/24 Melendez video. He says, I know she's taping me. We've known since the beginning. A direct contradiction to that.
And consent. And consent.
And consent. It's I cannot tell you enough. If you're going to go and look at any one thing within this document, go examine the heck out of this table because it is a thing of beauty. Every single thing that John says, Danny then puts a direct contradiction to and states specifically false. He starts out every single one of these sections on the right-hand side, false. Melendez admits in the video that he was, quote, feeding her false information. Quote, telling her everything. I want to bang her on top of the Eiffel Tower. Anything I can think of. So there you have it. So he, I'll keep him. I'll keep this going. Direct contradiction to Melendez's claim in his affidavit where he says that he felt deeply betrayed by Miss Meany's conduct. You can't have it both ways. You can't have it both ways is what this is saying. You're not allowed to. You're not allowed to.
And look, I know we all know John's dumb.
Yes.
Could he possibly be this dumb?
Yes.
Well, you know what? It's a stupid question because it got answered. He is because he did this. Yes. He knew what he was saying. He knows in the build up and preparation for this lawsuit, I think a reasonable person would have said, hey, did I say anything that might not make me look good on the internet where people are very unforgiving and have fantastic memories? But yeah, he's that stupid.
This is what I will say about that. And you can probably agree with this as well. When you are talking online for many hours at a time, you don't always remember every single thing that you said.
I understand. That's my point. But I think a reasonable person might have done a little bit of research and looked into it. Yeah,
that's what your problem is that you're considering him to be a reasonable person, which he absolutely
no.
is
He's
not.
an idiot. He's a moron.
Yeah.
I'm saying you and I might have done some preparation. Maybe Dr. Steve would have done some. Yes.
Yeah, you have to qualify with a reasonable person. Yes, that is the problem here. All right, so let's talk about the new video that this affidavit in opposition to that cross motion to amend introduces, because we have yet another video that we're going to look at here. This is a video from February 5th, 2025. So a couple of months after the last videos that we watched. Let's all not forget to look at how John is looking in comparison to just 2 months older videos. And this is when Melendez is going to admit on this broadcast that he knew that Kate Meany was not compensated, because one of the new issues that Melendez is trying to include in this is that Kate got paid, and that because of that, that is one of the reasons she should be added to the lawsuit.
And I'm sorry. I was going to say, let me just add just a little piggyback to that, is that, again, this is not relevant to a right of publicity claim. Yes. However, John opened the door to it. And we now get to contradict it to show that John has a pattern of lying. And he's also has this pattern of just saying nonsense things and bringing irrelevant items into this case. So I just wanted to make that clear and just say this has no relevance to a right of publicity claim. John only sued for right of publicity, which means that is the only thing that he can collect on should he win. Right of publicity. That's it.
Yes. Now, all right, so let's read through this. So it's Melendez attests in his affidavit that he, quote, only recently became aware through discussions with potential witnesses that there may have been compensation involved. And Danny continues on, this is a false statement. Let's check out the video.
Shit way it done for her. He hasn't paid her anything for any of these tapes.
Oh.
She somehow wants his attention, which is sad.
In his own words, ladies and gentlemen, that was, he hasn't paid her anything for these tapes. It really doesn't get any better than what he does to himself, does it?
I'm telling you, he should stop speaking.
Yeah, that would probably be smart.
All words.
Let's not forget, we're going to get into the doxing pretty soon, too. That's another fun thing we're going to be checking out. Oh my God, I literally can't. It's too much. This has all happened within the last 4 days, which is even crazier.
That's what's
it's
insane.
Even crazier.
So much happened.
So that is one of the main things that this affidavit is actually going through, is that new video. Again, of course, we have reference to the recent Clay Dabbler appearance, or I'm sorry, not recent. This one's the one from December. We already checked out that video. I cannot. One of the things that I think a lot of people get kind of confused about with this sort of stuff is, why is it so repetitive? Why is it so redundant? That's because what is happening here is Danny is responding to all of the allegations within different motions. And again, because Tabber has kind of muddled everything up again, he's muddled everything up within itself. Danny now has to respond and restate all of these things again and again and again as a matter of procedural practice. Am I sort of good on that? That's a okay description.
I mean, the thing is that Tabber does not seem to have any concern for structure of a persuasive argument, meaning that usually when you are trying to convince someone of something, you can't just lump a bunch of facts with different issues into one stream of consciousness argument, that you want it to be very structured, make point by point, almost argue it like acts of a play, in which, you start one argument, then you end it, then you start another argument, then you end it. But what's just amazing is, this is all an answer to your question, which is Tabber doesn't seem to have any concern for structuring a persuasive argument in an articulate way. Danny seems very concerned about being very, very good about structuring and articulating a persuasive argument, and that is the reason why things are done that way.
Danny is the only reason that I understand anything that is happening, because it is also nonsensical.
Yeah.
I would not be able to follow what happened if I did not have Danny over here finally explaining it and laying it out in a cohesive manner, because it's complete insanity. It's absurd. I will say, though, that the only thing that I think that Tabber is quote unquote doing right is that he is not just saying, you know what, I'm going to toss this whole case out, I'm going to dismiss this one, and I'm going to start a new one. That would be something that you would usually do if you messed things up so badly procedurally, you accidentally made mistakes, and you said, wow, I really don't want the court to see what a dumbass I am. I'm going to throw this one out, and I'm going to start a new case. In this case, Tabber cannot do that for John, and the reason that he cannot is because of the statute of limitations. So in this affidavit, Danny does lay out the statute of limitations issues, which is that on 8/7/2025, the plaintiff filed a complaint naming the defendants, Karl and Shuli, not naming Kate. Mm-hmm. And then similarly, on 8/17/2025, which was 10 days later, the 1-year statute of limitations expired for the events that happened at DabbleCon 2. He no longer could file a new action. And I will say that that is the only quote-unquote smart thing that Tabber has done, is that he has not gotten rid of the only index number that he is going to be able to be assigned.
There's still time.
There's still time. He might have filed something while we've been talking. Who the heck knows? That is his MO. That is his MO.
Yeah. And if that's the case, if he backs out of this and leaves John stranded with a statute of limitations issue, that is very definitely a malpractice lawsuit. That stuff happens all the time. Yeah. And I also do think that there is an argument to be made that the statute of limitations has already told, but
I think that there is an argument for that as well. I don't think that they're going to need it.
No, but we'll save that for another episode.
Yes. All right. So you might notice that I have an awful lot of things highlighted on this page, and that is because this is my favorite thing that has ever existed in any legal document ever. One time I read a divorce proceeding when I was working at my law firm. I read a divorce proceeding. I think it was a divorce proceeding. I can't remember exactly what it was, but it was something to the effect of, my husband has been throwing onions at me. And I thought that that was the funniest thing I had ever read in any lawsuit ever, until I read this. This is outstanding, and I cannot wait to get into it. But before we do, I am going to read a few more super chats because we do have so many of them, and I appreciate everybody's generosity so very much. And for hanging out with us, it is a pleasure and an honor to be able to talk legal stuff with Luigi and to be able to share all of that with you. So
you're way smarter than I am.
Oh, that's not true at all.
Hey, you know what? Go ahead.
You're way more attorney than I am.
While you do this, I'm going to run to the restroom. I'll be right back.
Yes, absolutely. Please. Signer Nesson. Oh, God, words are hard for me because I'm bad at reading. Right after Luigi said I was smart, geez. $5. Thank you so much. Luigi, thank you for saying verses as opposed to verse, as so many millennials seem to do. I have never noticed that before. I'll have to pay attention. The great Troy Smith is coming in for $5. When the case gets thrown out and John places blame on TB, what obvious nickname will he call him? Tabber Benedict Arnold or Backstabber Tabber? I think he's going to go with Benedict Arnold. I really, really do, but both of those are excellent. We have Drunk Crazy Karen Melendez for $20. Thank you so very much. Since SJ is obviously lying and not being honest, and Tabber isn't fact-checking, what happens when the lies are exposed? Does Tabber sue Stuttering John? His reputation gets hit. I don't think that is a thing that will happen. I think that that reflects just as poorly on Tabber as it does on John. And I think that Tabber is likely ruining his own reputation at this point. These two are perfectly paired for each other, shall we say. Smooth is coming in for $2. Thank you so much. Overruled, Greenberg. Mensa will always come in the end. I will make sure that Luigi is aware of your feelings there, Smooth. Thank you so much. Donna G, $20. Thank you to the lovely Donna G. Oh my.
Hey,
Watching this
Donna.
with my elderly father trying to explain the Michigas. I tried to explain this to my father the other day, and I'm pretty sure he thinks I'm an insane person now. So I don't know. Turd Ferguson coming in with $2. If John dies, does the lawsuit go away? His estate could theoretically continue it. I don't think he's...
All $7 of it.
All $7 of it. It's true. Oh, the amazing Raperbutt, my wonderful, wonderful colleague and person that I love to bounce legal quandaries off of. $5. Thank you so much. Your Honor, when I made those videos, my fingers were crossed. Yes, that is what he is doing right now. It's the steel toe defense. The steel toe defense is coming in hot here. Dankenstein for $2 is, Your Honor, I don't know, an effective argument. No, you cannot plea not knowing anything.
A valid defense? No. Will we likely hear John say that? Yes. Yeah.
That's also the steel toe defense right now, actually. Drunk Engineer for $2. A greater love. John for Kate or Tabber for Natalie? Ooh. I think
if there is, we have one love, we have one declaration of love in writing, Tabber for Natalie. If there's anything like that for John, I want to see it.
Okay, wait. So, but I think the answer is that John loves Kate more than Tabber loves Natalie. And here's why.
Yes.
You know, when your friends post on Facebook and they're like, oh my God, look at how cute we are as a couple. We're like the best, happiest couple in the whole wide world. That is, you know that they're having troubles in their relationship. That's like the number one indicator that somebody's having trouble in their relationship. Tabber literally did that in a legal filing. He was like, the love of my life, Natalie. They're not doing good, I don't think.
It definitely reeked of desperation.
It was not the smartest or anything to do. Tech School coming in for $5. Is it possible for him to take the LSAT online while a certain attorney is on the phone helping him?
No, it is not. And man, they make sure of it. I can assure you of that. Yeah.
We have Howard coming in for $5. Lucy, are you staying up all night reading these documents while I'm trying to sleep? And you still look this amazing. Thank you. Hashtag Queen of the Dabbleverse. I appreciate it, Howard. We have all, and by all, I mean, Luigi has been reading documents constantly. I'm sure that Karl and Shuli have been. I am pretty sure I'm working 16-hour days with this and my day job right now, but I'm having a dang blast doing it. So I'm just glad that we're getting to share all of this with you. Thank you guys for tuning in for my sleepless nights and for Luigi's sleepless nights and for all the dang laughter we've gotten to enjoy while reading these documents.
It's rare that you feel like you're doing something like for the greater good, you know?
Yes.
And this is one of those things. Yeah.
I always said if I was going to continue, I've been at the law firm that I'm at for about 13 years now, I think. I don't know what year it is. Over 10 years at this point. And I always say that if I was ever going to change fields within the legal practice, that I would love to do something like public defense or criminal defense, because it is so interesting to me. And I want to be able to help people out in situations like this. And so for us to be able to talk about this and kind of go through it has been so exciting and exhilarating for me. I'm having a blast at my friend's misfortune, suckers.
You are a
losers.
special person. You are a special person. I have been on the other end of that sort of thing, and I couldn't get out fast enough.
It is a challenging job.
It is a challenging
job. There's not a lot
yes.
of money in it, or at least there's not a lot in public defense.
I'll tell you some stories.
Yeah. All right. June Cleaver's Beaver for $5 Canadian. Thank you so much. How can she be getting compensation and be getting blackmailed at the same time by the same people? Great question.
Yeah, that is absolutely the same questions we're asking.
That is a really good one. Really good one. We have Dave D coming in for $20 Canadian. Your Honor, I'd like to call my first witness, the Eiffel Tower. I love that so very much. That is exactly what he would say.
I was supposed to bang Kate on you.
Why did you not let me bang like I was supposed to? We talked about this. DeWired Christian, hello. No booger tonight for you. I'm sorry. $2. Thank you so much. How soon will the civil court happen after this?
Huh?
I'm not entirely sure.
This is civil court.
This is the Supreme Court, which is yes. So I don't know. I think maybe you're asking about if there will be a second court case filed by Karl and Shuli after this to collect fees. I'm not entirely sure. I don't know is the answer to that question. You send me a message and I'll get you a clarified answer to that question, Wired Christian. Kyle X, $2. You going to our mutual friend Matt Harvey's birthday. I'm not, but I love Matt Harvey from Exhumed. He just started a podcast also, and I cannot remember the name of it right now because all I've been doing is reading legal paperwork, but his podcast is super duper awesome. Go check it out. I'm sure that it is shared on all of the Exhumed social media and stuff like that. I live on the entire opposite coast that he lives on, so I don't think that I will be there, but I hope you have a blast and a happy upcoming birthday to Matt Harvey. Ben S for $2. I keep putting Lucy as the, I don't know what LOML at my work, in my work emails. What's LOML?
It sounds
Am I stupid?
It sounds like
I don't know if that's good or bad.
Or not millennial stuff. I don't know. Oh, is that love of my life? Is that what that means?
Oh, thank you. That's so nice. All right, we got to get into my favorite part of everything. Look at all these highlights. I almost just want to read this verbatim because it is so dang good. This section of the affidavit in opposition to the cross motion to amend, it's a lot of legal words, I know, but we're going to get into the good stuff here, is what exactly is Exhibit D? That is hilarious.
I was tripped up by that too. So he's asking for the rest of us.
Thank God for Danny getting us all the much needed clarification that we need, or at least attempting to. So this is going to describe that Exhibit D to the cross motion is titled an attorney affirmation, but it's unclear what Exhibit D is. Here the defendants respond here to as best as possible. They describe it as a professional courtesy withdrawal of citation. What? Prior to defense counsel's 9/9/25 email, which relies heavily on cases involving the Honorable Justice Cohen, the judge presiding over this case of this court, Plaintiff had voluntarily removed a similar citation from the memorandum at law to avoid any appearance of reliance on internal bench rulings. This decision was made in the spirit of professional candor and does not affect plaintiff's right to amend under the liberal CPLR 3025B standard, which requires leave, quote, shall be freely given in the absence of prejudice or surprise. So Danny describes, defense counsel does not understand what plaintiff's counsel is saying here. And I think we can all agree that's a bunch of nonsense. That's boo hockey. I don't understand any of those words. And sometimes when I'm reading things like this, I go, oh, well, it's just something that I don't know because I'm only a legal assistant. I don't understand this aspect of the law. Danny is saying he also doesn't understand this, and that defendants tried to cite Judge Cohen's decisions and opinions. So when Danny responded, he tried to cite Judge Cohen's decisions and opinions in order to that all of these things are publicly available. These are the things that we should be citing, in fact, is basically what he's saying here. So counsel, go ahead.
No, I was going to say, I do not understand what the plaintiff is trying to argue, but I'm going to guess that what he's saying is Danny shouldn't be allowed to do that? Is that what the argument is? And I'm saying that as a question. I do not know.
Maybe what he's trying to say is Danny is being a ball washer. Don't listen to him, Judge. Is that effectively what we're getting at right here? Is that
the ball washing statute? Yes. Okay. Got it.
Taber's argument is the ball washing statute. That's what we're trying to say, which is stupid. That's absolutely stupid. You are allowed to cite any court cases. And I thought that it was quite clever of Danny to recite Judge Cohen's at previous rulings. I thought it was great. So
hold on. Let me add to that real quick. In that, as part of an argument, you want to cite precedent. Now,
yes.
The thing is, though, this might not be something that movies really focus on, and it might be a little inside baseball for people who aren't familiar with this, is that when you cite quote unquote precedent, it has to be spot on precedent in order to be controlling. And what that means is it can't, if you are in New York citing Ohio law, New York's going to say, what the fuck do I care what they do in Ohio? You need to cite something from New York.
Yep.
And also this jurisdiction. To be more precise, you can, of course, say, hey, this is how they did something else in New York, so maybe this is the direction you should follow, Judge. This is my argument that maybe this is how it needs to be done because somebody else did it before. How more precise can you be if you are citing to the absolute spot on court that you are currently standing in? Mm-hmm. So not only is he entitled to do that, it is helpful to do that. Yes. And for Taber to bitch, I'm not even going to say complain, to naggingly bitch about how dare he do that because that's sucking up to the judge. Well, that's what you do. And you are entitled to do it. And that's what they teach you to do in law school. This guy, man, ponderous, man, ponderous.
It's very ponderous. It's very ponderous. Perhaps the reason that Taber is feeling so bitchy is because the love of his life, Natalie, was bitching at him earlier in the day. We don't know. Maybe he didn't get his morning blowy. Maybe he didn't get his morning blowy on this day. We don't actually know.
It sounds
what
like
happened.
He might not be getting morning blowies on the regular because things are not going great.
They're not going great for him. They are not going great for Taber. He needs a vacation after all of this. I'm going to be honest. Let's give the man a damn vacation because he needs it. He's earned one after all of the stuff he's muddled up here. So this goes on. It says that plaintiff's counsel, and this is Danny quoting Taber, is, quote, concerned with the tone of defense counsel, but then admits defense counsel agreeing to extend was professional and appreciated. And you can't have it both ways. You're not allowed to have it both ways is basically what we have Danny describing here. And he lays it out so perfectly here. He says, since plaintiff's counsel raised the issue, though, It was plaintiff's counsel who refused an extension to respond via motion to the first amended complaint. Plaintiff's counsel admits this, but then conjures up a never heard before explanation of the reason that he didn't want a time to answer. And again, this is all about adjourning motions and when are we going to hear this and when are we going to do this by. Usually attorneys play nice in the sandbox and they let each other have additional time in order to respond to these very complicated motions. But here...
But I want to make it clear, it is not an entitlement. It is a courtesy.
It's a courtesy.
They are in no way responsible for changing dates. They can be granted, or I shouldn't say be granted. The opposing counsel can agree to a changed date, but it is in no way something that is entitled or deserved or required by law. It is a courtesy, and that opposing counsel has every right to say yes. They also have every right to say no. Now, what Danny is saying is, Danny was, I believe it was Danny was the first person to say, can we have an extension? And Tabber said, no, that doesn't work for me. And Danny said, okay, well then we're going to work hard and we're going to make the date that is already set. But then then Tabber came back and asked for 3 extensions. And Danny said, why would I give you 3 extensions if you didn't give me 1? And Tabber is throwing a tantrum and whining like a little bitch.
Yes.
Saying,
and Tabber's
I
argument,
didn't get what I wanted.
Well, but not only that, his argument, again, as Danny put it, his never heard before argument is that we're so concerned. We don't want to extend motion practice any further because we're concerned that the ongoing and continuing damaging activities of Karl and Shuli in breach of New York and Florida law, we're so worried that they're going to keep hurting our little baby John. We can't let that happen. So because of that, we don't want to delay this any further. We want the courts to look at this as fast as possible. And Danny responds to that. This is false. Plaintiff's counsel was not concerned about any extension situation. In addition to that, they kept requesting those additional extensions of time. Another extension, he quotes it. And then another extension, and he quotes it. And this, oh my good God, it is so hilarious to me. I cannot tell you enough how much I love this writing in paragraphs 68 and boing boing 69, which we will get to in a second. The same attorney who claimed to be so concerned about the ongoing and continuing damaging activities of the defendants in breach of New York and Florida law that he could not grant defense counsel's reasonable request for an extension, asked for 2 extensions himself. And now he's traveling out of the country for 2 weeks with Natalie, the love of his life, and he doesn't want the court to schedule anything. You said we have to do this now because I cannot let my client wait any longer. Stuttering John can't wait any longer on this. And then you were like, well, love wins, Judge. Love is more important than my work. And I want to go hang out with my wife. I don't even know if it's his wife. The love of my life, Natalie. And Danny continues, hopefully there will be none of this ongoing and continuing damaging activities he's so concerned about while he's gone on vacation. Ba-boom, boom, boom. I love this so much. He says, he continues, I want to be very clear here. I have no objection whatsoever to Mr. Benedict's vacation abroad with the love of his life. But when Mr. That sentence in and of itself is friggin' beautiful. But when Mr. Benedict said that he couldn't grant a 2-week extension because he was concerned that defendants might mention his client's name on a podcast, well, that's just not credible. Worse, he tried to turn it on me, on Danny, with some manufactured concern about my tone when there is obviously none. I apologize for any snark. I hope the couple have a lovely trip. I will also readily admit that Mr. Benedict is otherwise exceedingly polite in his communications.
It's amazing. And I know that we're probably already here and on the same page to the viewers, but we have to just clarify this. This is not substantive arguments of law. This is bickering about dates. That's
Yep.
all this is. We haven't even gotten to arguments about the law yet. And this, somebody sent me a message on X a little while ago that said, I think it might have been earlier today, that said that this is an effort for John to try to delay proceedings, which I admit that at first glance, that is exactly what they're doing. They are asking for extensions to delay.
Yes.
What is amazing, though, is that if that's true, they have done it in such an unorthodox and procedurally inaccurate way, they are jeopardizing their future ability to continue practicing law because they've done everything wrong. There are ways to delay. There absolutely are. There's a way to do them right, and there's a way to fuck it all up and do everything wrong and turn it into a dumpster fire that is only going to annoy a judge, and that's what Tabber has done. So
It really is. It
Yeah.
really truly is. And oh, God, I just can't get enough of it. I mean, again, it's awful, but I just love, I apologize for any snark in a legal proceeding. That's, God damn it, Danny. We are going to get into yet another affidavit. We're going to skip around a little bit here because I really want to get into all of the stuff that happened yesterday and today, and we've been going for quite some time. So we're going to just take a very quick look at the affidavit in opposition to the cross motion to stay and for discovery. So again, more legalese there, but we're going to talk about one section in particular when it comes to this, because I would like us to discuss the now infamous doxing concerns, which of course introduce yet another video into the proceedings here. So we're going to skip ahead a little bit in here. You'll notice I had some other talking points that I wanted to talk about within this. We're going to skip ahead on them for now. I am sure that we will go back and talk about these documents in more concise detail at some point, but tonight's not the exact night for that. Instead, we're going to hop over to a completely brand new section that we have not seen in any previous documents in this affidavit, which describes the realistic fear that plaintiff will dox the defendants. So John, through his attorney Tabber, has requested financial information and discovery from the court. And Danny here is responding to him. He's saying that the defendants have a very reasonable fear that Melendez seeks his financial information so that he can dox the defendants or publicly reveal their confidential information.
And
this
real
is
quick,
something...
I just want to say that is contrary to the whole point of a motion to dismiss. That the purpose of a motion to dismiss is is asking the judge to make a determination of the validity of the lawsuit based on what is contained in the documents submitted to the court. That is all. That is the whole purpose. That is everything about what a motion to dismiss is. And again, talking about unorthodox and just completely out of the ordinary procedures, or just not doing it within the procedural bounds, Tabber says, well, that's how it's done, but that's not how I want to do it. I want to skip all of this and go to discovery and learn more about it. That defies the whole point of it. And that's just not going to go well with a judge's future interpretation of what's expected from this motion to dismiss. And I just wanted to set all that up for what you're saying, is that Danny is saying that the reason they're asking for that completely unorthodox procedure is that they believe it's intended to dox the defendants, and they give an example. So that was all just to set up what you're about to say.
Well, and it is the perfect example because Danny filed these papers, this exact paperwork, on 9/18, and he was able to pull up an example of doxing from 9/18. John is doxing people so frequently that it happened on the day that this filing happened. And they submit an entirely new video where John Melendez doxes a fan who he believed was showing him disrespect, and then spent several minutes threatening him and saying that he was going to come find the fan. So again, you can go and watch this entire video. I'm only going to play a small clip of it because at one point this fan does in fact super chat John after John doxes him. So the fan gets doxed by John, and then the fan super chats and is like, oh, great job. So we're going to check that portion of the video out now.
Jackson, thanks for the $5. Way to dox me, deadbeat. It's not like I have my name and pic in my profile. I know that. But that's how stupid you are, you dumb fuck. Now I know what you look like. Now I have a bunch of pictures, and they will be all over the wall. Just so I can remind myself when I see your fucking lame ass. Then I'm gonna go. Excuse me, bouncer. You can keep him in here, but take away his phone until the show's over, because I don't want him recording my set. Not like I give a shit anyway. Everyone's heard it anyway, you dumb fuck. I'm the last person that you want to trifle with, okay? I guarantee fucking see that. You have no fucking idea.
Now, I'm actually a little bit disappointed because I thought that I included in there, he does do the YouTube's terms of service, however he says it incorrectly. He does do that in that full video, but of course I cut that portion out, which is just hilarious to me. We got so many dang good
And I believe
things.
there is a direct physical threat in there. There
absolutely is.
Yeah.
And in the other portion of that video, we also get the, at one point, John goes, thank you, what does he do? He goes, thank you, crackhead Bob. You're welcome. Which I just imagine a judge not understanding any of the context to, and being like, what in the fuck is this lunatic doing? Why is he talking to himself? Who the hell is crackhead Bob? Like, I have to imagine that when the judge watches this video in particular, he's going to go, I have no idea what is going on within any of this.
I would love the judge to say, Mr. Melendez, crackhead Bob never said you're welcome.
Yeah.
He gets that quote wrong all the time. I
know.
hate that. It's so infuriating.
Oh, listen, give the man some credit. He needs it somewhere. No, don't actually do that.
No.
All right. We are now going to get into the most recent letter that was filed by Tabber. So this is going to be just from the other day. When was this? This was from yesterday, right?
Late yesterday. I think it was already in the evening when this got filed.
Late yesterday. So this is a letter from Tabber that is quite nonsensical, if you ask me here. I am
we're going to talk about exactly how nonsensical it is.
I'm relatively unimpressed by this thing. Why don't you get us started on why exactly this letter is so nonsensical?
Because this is not how you do things. And we've already established that Tabber has no regard for procedure, no regard for doing things the orthodox way. Request for adjournment of all pending motions. That needs to be a motion, not a letter to the court.
Yes. And I mentioned the court's part rules previously about this. This court in particular, Judge Cohen does not like letters. He has said, don't send me letters. I don't want them. Please do not give me them. Continue.
I mean, I realize we are using up our, our good faith quota of the word unbelievable, but this is
it's unbelievable.
Believable. Everything this guy does. I'm telling you, I think this is performance art or something going on. It makes no goddamn sense. But
so what does this letter say?
Let's talk
about what the letter says.
All right, you're right. This is more bitching. This is more complaining and nagging that Tabber didn't get what he wanted. The things that he is not legally entitled to. We can probably just skip these these first couple of sections because he summarizes all of it down here at the bottom. But he's talking about dates, and he's saying exactly what was said earlier that we discussed. Hey, I asked for dates, and they didn't give them to me. I know that I'm not legally entitled to them, but I want them, and I'm going to start stomping my feet and holding my breath until I turn blue. And that's really it. But also, in addition to that, he is trying to make an argument that he is entitled to certain things that he is not. One of the things is saying that, like we said earlier, and I believe this is the thing that I said that it was important for us to establish, which is when a motion is filed, there is a response to the motion from the opposing party, and then a reply from the party that initiated the motion. That's it. He is saying in one of these sections, I forget which one, that when the reply from Shuli and Karl's lawyer was filed, that it was filed too close to the deadline of September 19th, that he didn't have an opportunity to respond, which is not procedurally accurate. There is no response expected. And
None of this makes any sense.
He is trying to argue a law or a procedural aspect that does not exist to the judge of the court and saying they should have given me more time.
Not only that,
Respond to something I'm not supposed to respond to.
Not only that, this letter was filed the day after the motions were marked submitted. Once the motions are marked submitted, that means submissions are done being taken. We were predicting, and I believe that we did this off air. We were like, when is going to be the day that Tabber files another document even though he's not supposed to? And I was like, tomorrow. And I was right. And that's the most absurd thing. I was making a joke about that because it makes no sense for this to happen.
I sent you a message and I said, you should have taken me up on my bet because you would have won.
It's so incredibly insane. And again, I know we keep using these words, insane, absurd, egregious, all of these things, but it is. And the point of this letter, so you mentioned that the bottom of this here, usually when I'm reading legal documents, a lot of the time I'll start at the bottom because they'll give me kind of the summary of everything. It says here, the conclusion is that Tabber is requesting an adjournment because it would allow, one, to remedy the defendant's procedural violations inaccurate, two, to ensure adequate briefing time, totally irrelevant because there's no briefing time, three, accommodate legitimate scheduling conflicts, and four, promote judicial efficiency through a consolidated return date /hearing. We've already had that. There wasn't going to be a court date in any of these times. But more crazily is the scheduling conflicts that he lists. Now, Can I just add one thing real quick to what you just said, which is he is talking about judicial efficiency. The guy who has not abided by not abided by filing procedure one time. Single time.
Is talking about judicial efficiency. Just want to throw that out there. That's it. Go ahead.
Yep. So why does he want to adjourn this? We already know about his travel plans with the love of his life, Natalie, which will be through October 11th. But in addition to that, he is citing Jewish holidays, including Rosh Hashanah, Yom Kippur, and Sukkot. Now, let me just talk about that for one quick second here. First of all, Lishana Tova to all the Jews out there. It is Rosh Hashanah. And you might notice that I'm working because I'm not a pussy bitch. But that's, I suppose, irrelevant. Happy New Year to all. It's very exciting. Eat your apples and honey for a sweet new year. That will help Karl and Shuli very much, I am sure. It is very common for people in New York City, especially in New York County, to request adjournments based on Jewish holidays. This happens all the time. And I see a lot of people saying like, oh, maybe John suggested to do this. This is a very common reason that people seek adjournments, is they kind of rely on the Jewish holidays. What is peculiar here is that I don't believe that Tabber is Jewish. In addition to that, Tabber has co-counsel, Bennett Susser, who theoretically should be able to look over everything while Tabber is out of town during the Jewish holidays, whatever. And more ironically, I believe that Susser is Jewish. So why is Tabber arguing the Jewish holidays when there is another attorney who very much could probably legitimately argue those?
Can I also ask you,
Yes.
are those dates of the Jewish holidays accurate?
I believe they are, but I am not
They are
very
not.
good. Okay, I believe you. Sukkot is earlier than that. Is Sukkot earlier than that?
Yom Kippur is not on that date. He gave the wrong dates.
Oh, buddy.
I
buddy boy.
believe Yom Kippur is in October.
What a good Jew I am that I didn't even know that. Jesus.
I
fine.
believe. I could be wrong, but
I'm not practicing.
hold on. We can Google it. There's
Yeah,
this thing.
yeah.
We can just Google it.
Why not find out? I am going to make a sukkah this year, though. I'm pretty excited about that.
It is
Sukkot.
Thursday, October 2nd.
Aw, buddy.
And
Buddy boy.
so he's given the wrong dates for the holidays that he is asking for off. But also, he's already
Yeah.
said that he's going to be on vacation. So what does it matter? But also another thing is, if you do the math on these things that he's talking about, I want to read this out because this is all right. Let's see, number 2 under the defendant's procedural violations. I'm sorry. Number 2 under procedural history and good faith efforts. Okay, listen to these numbers. All right, filed September 15th, 2025, properly noticed for September 23rd, 2025. Okay, provided 8 days notice exceeding the 7-day requirement. So he's like kind of talking about where something starts, where something begins, and what he's done as far as notice. Okay, now let's move down. I believe it's number 1 under defendant's procedural violations, filed September 10th. Wait, is this the right one? Hold on. 2 days after the 7 days. Ah, shit.
Are you
I lost
going
my.
off
Oh no, here it is.
Well-
Okay, filed September 10th. Properly noticed for September 19th. Defendants filed opposition on September 18th. 5 days. God, no, that's not it either. I'm sorry. There was one of these that actually talks about how a 13-day period had lapsed over the course of 8 days. I can't remember which one it is.
Danny's response to this is truly incredible. That is what we got today. Just a couple of hours before we started the stream, Danny filed a letter response with the court in response to this specific letter from Tabber. And that is really, truly, if there was ever an opus that Danny has written, that is it. And I cannot wait to talk about that. It's almost mind-bogglingly good, right?
Yeah.
It's got to be one of my favorite
so
things
good.
that Danny has done so far.
Yeah.
It's got to be. It's got to be. Before we get into that, we are going to hit a few more super chats because, again, I know you guys are asking all the great questions in the super chats. I really appreciate how much there have been questions in super chats. I know sometimes super chats can get a little bit boring for people. I know that's not everybody's favorite thing in the world, but this is actually allowing us to answer your questions. So it's been really exciting for me. So thank you. And also thank you for your generosity.
Thank you very much for your generosity. But one thing I do want to make sure that we do not pass over, speaking of the Jewish thing, is that he is accusing, Tabber is accusing Shuli and Karl's lawyer of missing a deadline.
Yes.
Who is the only person who has actually missed a deadline in this case?
Who could it be?
Tabber
Tabber?
is flat out lying about these quote unquote missed deadlines. The only person that has missed a deadline was Tabber. His response to the motion to dismiss was supposed to be due before midnight on September 12th. He filed it, I believe, a couple of seconds after midnight on September 13th. So, if we really want to be dicks about it, we can point out who missed the deadline. Oh, wait a minute. We are dicks about it, and Danny totally points it out. But we'll get to that in a
Danny's
little bit.
a genius.
So,
Danny's a
go
friggin'
on,
genius.
please.
All right, let's do some super chats here. Ugly Poxguard Ghoul for $2. VTL is paying Tabber and writing the pleadings. I don't think that that's a horrible theory.
No, I
Jay
don't.
Wolfenstein.
I don't either.
Jay Wolfenstein for $2. It sounds like Tabber gives the morning blowies.
Yep.
We could
He did in
only
prison.
be so lucky. Yeah. Kelly Riddle for $2. I just wanted to say Karl and Melton are creepy D-bags. Oh, neat. We don't usually get Melton dragged into things over here, so it's good to know that now for the first time ever. Ugly Poxguard Ghoul for another $2. That, quote, fan was threatening John with violence. Threats are never any good. John O'Reilly for $5. This case is summed up with the image of an open-mouthed John and Clay within an elongated face mask. His head is surrounded by fire. It's worth 1,000 words. Danny's done a great job of choosing his screenshots to include as images in all of these motions and oppositions and replies. He's doing a genius job of what he is selecting for his screenshots. Donnie699 for $5. John wants to take Kate to the top of the Eiffel Tower because it has a sharp point and he wants her on top. I think that he wanted to take her to the top of the Eiffel Tower for several reasons. BMC for $5. Jewish law says that you don't need to take the whole holiday off. The first 2 days of Sukkot work is not permitted. After that, it's basically fine. Yes, it is extremely irregular to take off of work for Sukkot. However, that being said, many attorneys do argue this in New York City, is that anytime there are Jewish holidays, we should take those off because we don't know exactly who is going to be doing what. So I will say this is a common argument to include the Jewish holidays. Why he didn't make that argument previously and why he's making that argument when he has co-counsel, I have no idea. And Tony Baloney coming in for $2. Hey guys, Lucy Tightbox World Order. Thank you so much. All right, let us get into my favorite. Oh wait, we have so many more super chat. Oh my God, you guys are incredible. Thank you. We'll hit a few more of these. Thank you. Tactic Reticence for $2.79 Canadian. I'm doing great. Lucy's not practicing Judaism. She's perfected it. I am a really great Jew over here. I am Jewish by heritage, not by religion, is how I like to define myself. Voltaire for $3.25 for $5. I thought VTL was running this, but he is not incompetent. These are Stern fan hack attorneys doing this for free. They doxed SJ's email. Oh, I don't know about SJ's email getting doxed, but
Oh, you don't?
oh no, what am I missing?
We're about to get to it. I'll point it out. Yeah.
Oh, I know. Okay. I thought that something else happened. Never mind. I do know about that. Yeah, okay. It is the thing I know about. All right, Jared, $5. Thank you so much. So what I have gathered from all this is everyone hates love. I'm rooting for Tabber and Natalie as well as SJ and his couch cushions. #love wins. I am also rooting for everybody to be in love all the time. Love is the most beautiful thing in the world. And sometimes we forget about that when we're talking about all of this craziness. But it is a beautiful thing that Tabber is happy, and I do want him to have a wonderful vacation with the love of his life, Natalie.
Tabber did not mention that Natalie was his wife. I think we should all start a rumor that Natalie is his babysitter. Love wins, folks.
Is Natalie the nanny? We'll never know.
Yeah, we'll never know.
Love does win.
Love of his life.
All right, we need to get into this beautiful, beautiful, beautiful letter by Danny, Karl and Shuli's attorney. This was filed today at around, 3 o'clock in the afternoon, I want to say, someplace in that vicinity.
Something like that, yeah.
Not that long ago, and oh my good God, do I love it. I love it
It's
very
great,
much.
and I have to say that if he really wrote this just this morning, I am impressed.
Danny seems to have taken this on at this point as a passion project. I believe that at this point, because Tabber questioned Danny's ability to practice law, that Danny went, oh, fuck this asshole, I'm gonna get him. And I think that letter that Tabber filed yesterday has just turned Danny into even more of a shark, and I think that this letter proves it. You do not question a lawyer's veracity to the court, especially when that lawyer is as talented as Danny. This was a silly thing that Tabber did, and I think that Danny is now going to be taking everything and like full steam ahead on this, is what Danny is saying with this letter. He's done.
Yeah, exactly. You are 100% correct. It is also a fuck this guy, I'm tired of him wasting my time. So,
yeah. Oh, absolutely. Yeah. So what he starts out by saying is defendants object to plaintiffs' request to file replies to their cross motions. Cross motion movements are not entitled to replies. So first of all, you're not procedurally allowed to do the thing that you're asking to do. Mr. Benedict proposed, drafted, and agreed to a stipulation with deadlines for filing of these motions. And now he's complaining that he didn't give himself enough time in the stipulation. He's the one who chose the dates.
Yeah. He agreed to it. It was written.
Not only did he agree to it, he's the one who wrote it. He's the one who drafted those stipulations. He chose the dates.
Yeah.
I mean, they all agreed probably separately to the dates, but he is the one who actually drafted this. So what Danny is requesting here is he's saying defendants respectfully suggest that a brief conference be held in order to address Mr. Benedict's filing practices, because that might be productive, because at this point, what the fuck? He is saying to the court, I know there's not supposed to be a court date yet, but we got to talk about this, because in the weeks since he has commenced this case, Mr. Benedict has filed documents on an almost daily basis. Again, I went through those days a little bit earlier. What did we say? He filed documents on 9/11, 9/12, 9/13, 9/14, 9/15, 9/16, 9/18, 9/20. This is 8 out of the last 10 days.
Now, I want to make it clear that what he is saying here is, let's all get together with the judge.
Yes.
He is saying... Now, the only real analogy that I can make for this is basically when you see a coworker doing something bad that might possibly have an effect on your job, and you want to cut it off at the head with your boss. So basically what we're seeing here is Danny saying, Judge, I'm participating in this because it is my job to, but I think there's something very, very wrong here. He is saying, I do not want my participation in his nonsense to make me look bad, and I want to make sure you understand that I don't agree with how these things are going.
Yes,
that's the best way I can describe it. Yeah,
I think that's the perfect way of describing it. This is him. It's saying I need the court's intervention at this point because it's so incredibly, incredibly insane. And Danny continues. He says, I regret sounding critical of counsel here, but several of these documents are procedurally unorthodox. Many of them are completely irrelevant to the issues, and some of them are just indecipherable. Again, he's hitting with the two-handed punch. I love how Danny does things, because he's like, I'm not going to stand for this BS, but also let me be polite about it, because that's what I'm supposed to do as an attorney.
And professional.
And that's what he does. He's so professional, and he does it so well.
Yeah.
He continues here. Worse, each of plaintiffs, each of Tabber's, and on behalf of John, each of John's filings begets more filings because defense counsel, because Tabber must correct his own misstatements with citations to the record, lest the court think defense counsel is ignoring or silently approving the filings. Unfortunately, Mr. Benedict will likely feel compelled to respond to this letter with yet another letter, creating more filings. So, Luigi, I guess what we have to do at this point is we have to guess, when is the next time Tabber going to file a document?
It could be tonight. It absolutely, and I'm not even saying that as a joke. It could be tonight, but I really think something's gonna get filed tomorrow. No later.
I'm going to go with tomorrow. Although I do think that he watches our videos, so it's possible that he's going to wait just to prove
I'm gonna
us
check
wrong.
right now. I'm gonna check right now. Okay.
Right now,
No,
yeah,
no-
you check
nothing
right now
filed.
while I continue along on this.
Nothing filed yet. All right.
All right, so Danny continues along, and he is describing these near daily filings that all follow a similar pattern. He says Mr. Benedict's chief complaint is that he didn't get enough time to file replies in his cross motion. The cross movement does not have a right to reply. You might remember that I talked about in the beginning of this episode, it was a while ago now, but I talked about the actual procedure. What happens is the motion gets filed and served, the other side gets to file opposition, and then the moving part, the person who initially filed the motion, gets to file a reply to that.
That's it. And that's
it. Those are the
That
three
is
documents that get filed within those things. You don't get another time to reply. Second, defendants have not systematically violated timing requirements. This is where Danny's like, oh, fuck that. You are not allowed to tell the court that I have done bad.
It's just.
Third.
First off, it's a lie.
Yeah.
And I think Danny's really, really smart to do this, because a lazy lawyer would have just said, the Tabber guy's filing something else. Let me file something in response. And then just waited until the case went to the court. And I love that Danny is being very proactive about this and just saying, Judge, look, this is probably getting filtered through with your clerks. You need to see what's going on.
Yeah. Yeah. We need you at this point. We need you to
Yeah.
come literally play judge. Or, I don't know, just rein this guy in because his conduct is absurd. Third, Danny continues, the motions are fully submitted pursuant to a submission schedule that the plaintiff himself agreed to in a stipulation. We talked about this already. It doesn't matter. Why did Tabber file this letter after the motions had already been marked fully submitted? They were already submitted. We don't need to do this. It's nonsense. It's absolute nonsense. And fourth, Mr. Benedict complains that the defendant's documents were late because they denied plaintiff his supposed right to file replies to the cross motions. But meanwhile, Mr. Benedict violated his own deadline. Now, we already discussed all of this, and what Danny has done in this letter is so concisely explained this so that we can all understand it finally. Because again, there's just so much that it would be near impossible to understand what the heck is going on with Tabber's I don't even have a word for it. With Tabber's blech. Like, it's word vomit at this point, what he's doing.
His lack of procedure, or lack of respect for procedure. Maybe that's a good way to say it.
Absolutely. Fifth, it seems Mr. Benedict just wants to bring endless briefings in these motions. This case is roughly 6 weeks old, and there are already 73 filings. I think Dr. Steve corrected that and said that there was 74, but he says roughly 73 filings. That's absurd. I have never seen a court case with this many things within it.
Before trial.
Yes.
And before trial. Yeah.
Yep.
Like, what I mean by that, folks, is that at trial you expect a large number of filings. We haven't even gotten to the phase before trial. There's too many filings.
Yeah, there's way too many. Sixth, as far as I know, this is the very first time that Mr. Benedict has invoked the Jewish holidays as a need for extension. The only reason he has given so far for being unavailable is his vacation abroad with Natalie. Of course, I have no objection to religious holidays or vacations abroad. I do, however, object to him suggesting that I somehow resisted a request by Mr. Benedict to celebrate Rosh Hashanah, Yom Kippur, or Sukkot. I never did. Defendants... Go ahead.
No, I don't have anything to say. Just, ugh. That's it.
Defendants respectfully request that the court deny plaintiff's request for replies and more time. Meanwhile, I respectfully ask the court to consider stepping in to regulate Mr. Benedict's filing habits. Judge, stop this maniac. Stop this maniac from doing what the heck he's doing right now.
That's it. And just judge, and it's also, the thing is, a judge is also going to give a wide lane to lawyers to some extent, like basically just saying, hey, maybe you're not familiar, here's a chance. I'm curious if the judge is going to see the consistent lack of respect for procedure as disrespect to the court. I wouldn't be surprised, but a judge is simply going to, or what I expect that conversation to be is Danny saying, Judge, how do you want me to proceed with this now that we know this guy doesn't know what he's doing?
Yeah.
And that's going to be up to the judge to decide. And also another rake for John, because had there not been these letters, there wouldn't be a need for Danny to have this conversation, which is now going to put a microscope on the lack of respect of procedure by Tabber, which could also lead to a dismissal outside of the motion to dismiss. Should the judge be so, I don't know, motivated to just say, you don't know what you're doing, go back, try this again. And then you get a hard enough judge and Tabber says, well, we can't, it's a statute of limitations. And that judge is going to say, sucks for you, buddy.
No. Yeah, the judge does not care. That is not ever going to be a thing. The judge will
Absolutely.
not care. The judge will not care that the statute of limitations is blown on this. That's your fault for not doing it correct in the first place. That is your fault for not doing it correct in the first place. If you were not an idiot, then you would have been able to proceed. Fine, whatever.
And maybe that's my mistake for anticipating stupid. But that's what I see Tabber as being his response and saying, no, you can't throw this out because it's a statute of limitations. And man, when you tell a judge he can't do something, you better be prepared to have a bad day. So,
oh yeah. All right, what else do you want to hit in this letter?
I'm just so impressed by everything. I don't know that I could really put my finger on anything. My favorite line, my absolute favorite line is, I regret to sound critical. Or wait, where is it? Hold on. I regret sounding critical of counsel here. That's my favorite line. It is just basically saying, look, man, we have professional standards and you aren't living up to it. And now I'm going to tell essentially the boss. The boss is now going to put every piece of your work under a microscope. He's requesting. We're not going to say that it's with certainty going to happen, but there's just no reason why it shouldn't. Because usually when you ask a judge for a conference, that judge will usually grant it because there is a what's the word I'm looking for? Kind of a undercurrent of negotiation under it, which basically is the judge saying, look, we're all in the same room. Let's all talk. Get this off my docket. Yes, and
absolutely.
Yeah. And so by calling a meeting like this, the judge may entertain it, but it's not going to go well for Tabber. So,
yeah, that section that you just referenced is in paragraph 2 here up at the top. I also really particularly love how Danny closes this letter out. He says, Mr. Benedict can make his points without using such loaded terms. Ultimately, whether or not plaintiff is granted leave and time to reply, all defendants ask for is the court to consider defendants' filings and decide on their CPLR 3211A and G motions and give the required 3211G priority to the anti-SLAPP motion. So he's saying, listen, court, we just want you to kind of take a peek at this, but we also don't really appreciate this candor right now. It's not going great. Again, I think that Tabber needs that vacation. He's going to come back and he's going to be feeling great and everything's going to be going swell for him, right?
I wish I knew what's going on in that guy's head. I wish I knew, but who knows? And I don't know anything about this guy. I don't know why he would think any of this is a good idea. I don't know why he wouldn't ask someone, "Hey, do you think maybe I should do X before he does it?" So there is a layer of unpredictability with this. This is a wild animal. That's what this is. We're dealing with a chimpanzee in a suit trying to practice law, and you never know what he's going to do. He might throw shit at you. He might smoke a cigarette. He might rip your face off. Just totally unpredictable.
Some might say a buffoon.
Some might
say a buffoon.
And real quick, I don't want to take credit for this. This was said to me, but I loved it and appreciated it, which is how amazing. And what are the odds that John found his doppelganger and an equivalent moron practicing law in New York?
Yeah.
It's amazing.
I think what we've learned today is that love will always find a way. That's the true answer to what's going on, right?
That's it.
Love
wins.
Is a love story to end all love stories.
And
it's a beautiful, beautiful thing.
And if you're a fan of Uncle Rico, you're going to learn this is par for the course for John. This is just absolutely if anyone is writing a novel on the history of John's rakes and fuck ups, this is it. And please, folks, I will repost it again on X. I went on a long tirade on my show one time with Mr. TV's Will Heron, who asked a question about John's legal history, and I gave a full rundown that John does not pay for lawyers, and he always gets what he pays for and never learns his lesson. This is what happens when you don't pay for your lawyers, because they don't have a vested interest. They don't care about your case. They are not interested. They are doing a favor, and they want to get you off their back because you're not paying them.
On that note, I will remind everybody, please go support Karl and Shuli now, because they are paying for this. So make sure that you are supporting Who Are These Podcasts and the Shuli Network. I have their Patreons linked down below, but you can also support them just by liking and following and listening to stuff on YouTube. You can support them with super chats and super tips and just any general support, saying things in the chat. All of that does help. This is a very important time for them to be getting all the support that they can, because even though they are requesting attorney fees and costs, it is my belief it is very unlikely that they will get those. This is more than likely going to come out of their pocket. So please go support them. And in addition to that, Luigi, you mentioned that you were going to post that video on your Twitter account. I would love it if you would remind everybody where they can actually find that, where else they can find you. Exciting things coming up. And then after you do that, we'll hit some more super chats.
Sure. My channel, Luigi Greenberg on YouTube. You can also hit me up on X at Papa_Electrico. I host a show on Fridays called Skeptical Robot, which is a show that is dedicated to discussing frauds, con men, charlatans, and exposing the paranormal. This past week, we actually discussed Harold Camping with Shmuel Buckman. Harold Camping was a pastor who convinced his congregation that the world was going to end and convinced them all to liquidate their retirement accounts, run up debt, and quit their jobs, and the world didn't end.
Oh, boy.
It was a pretty funny episode. And then we just started sniping Karmic. So also on Tuesdays and Wednesdays, I also am a co-host on a show on Hack Ride Studios, unboxing Riley Martin and unboxing Bigfoot It Is, and unboxing Eric the Midget for the Stern fans. That is Hack Ride Studios. Please also check out my co-hosts, Casey Day at Hack Ride Studios, DJ Electra, Corndiff, and Gummy Chainsaw, who gummychainsaw.com. You can find our merch store for Skeptical Robot stuff. Thank you.
Yes. all absolutely amazing people. I always like to remind everybody that DJ Electra Fry actually did the intro for Lucy Does Dabbleverse, but all of those people are incredibly talented and deserve a follow very much. In addition to that, Luigi and I will be on the 29th doing another episode of Edge Files. So if you have not checked out Edge Files, that is where we talk about weird, bizarre cases. And Luigi, remind me what we're talking about on the 29th?
We're going to be talking about the life and death of Bob Crane. And this one is odd. Odd, folks. A little odd.
In addition to that, you can also find me on Patreon at Once Over with Kaylee, Cayley. I forgot my own Patreon for a second there. It was great. Over there, I do popsicle reviews, other thing reviews. There's lots of good stuff. But I, again, would implore you to support Karl and Shuli right now in this time.
Can I make one other statement? I had someone reach out to me that we incorrectly cited something, and that was...
boy, what did I do?
That was that we said that Bennett Susser's stand-up comedy was not on Tukey Soup. It was actually on a special hosted by Cardiff Electric.
I wonder who could have possibly reached out to you about that.
I don't know. It's somebody.
I'm sorry that I fucked it up. I'm sorry. I'm the worst. Oh my God.
Yes.
There's too much to think about right now.
I know. And honestly, I didn't even catch it when you said it. I knew that, but I didn't even catch it. But yes, it was Cardiff Electric. It was an emergency show on September 12th, but I believe it is now behind his Patreon wall. So check it out. There you go.
Yes, go support Cardiff Electric. Go support Tukey. Also, don't forget to support Dr. Steve, Weird Medicine. Amazing. We're so glad that he was able to join us and rein us in a little bit here in the beginning. Let's hit some more super chats. We have John O'Reilly for $2. Tabber, clearly diverting attention from SLAPP. Yeah.
Yep. Trying.
Oh, yeah.
Trying to.
Trying. Yeah. It's not working. It's not working. At least I don't think it's working. We also have Tony Baloney for $5 more. Thank you so much. Your breakdowns are really easy to follow. You are providing a much needed service. Thank you. That is what we strive for over here, because I think that this has become very much a passion project for Luigi and I at this point. We really enjoy being able to talk through this with you guys. And I'll tell you what, doing this has helped me understand more of what's going on, because otherwise it's just nonsense. So thank you guys. Beloved Cheddar for $4.99. Thank you so much. Sent a super sticker.
Thank you very much.
And John O'Reilly for $2. Believe it or not, Tabber is a graduate of Columbia Law. I made some very wild accusations about that earlier that I will not repeat. But if you want to hear them and you have not already, you might want to go back and watch this episode from the beginning. I have no concept of when I said those words, but I did make some crazy time stuff up in there.
Yeah, fuck 'em.
That's a great way to... Love will always win, and also fuck 'em is how we are going to conclude today's episode. Luigi, thank you again so much, and thank you guys so much for being here. I cannot say thank you enough. Go support Karl and Shuli. They deserve it. They have earned it. They are going through it.
And even if you don't like Karl and Shuli, just help them to stick it to John, because this is a good versus evil, line in the sand, black and white issue. Fuck John. I hate that John is doing this out of his own egocentric purposes, but wasting court time, lawyer time. It's wrong. It's wrong, folks. This is absolute nonsense. Please help Karl and Shuli, even if you don't like them. Just fuck John.
I think we will end this with fuck Stuttering John.